My lord, item 50 and 51 of supplementary list. These two matters may kindly be updated.
What is the urgency?
Because my lord, since last 4 years back, my son was killed. There is a custodial death, some interim protection.
Achha, custodial death.
Yes, sir.
50-51. Okay.
Yes. All right.
Lordship, I beg to mention item number 39, Lordship, of today's list. Lordship, Mr. S. Islam will argue the case, but he's out of station due to his father's illness, Lordship. So kindly may be fixed after 1 week.
39 after 2 weeks. 39. Outside the okay.
Please, Lordship. Lord, I have plain item 28, my lord. 28. Lord, my father as well as my mother-in-law is not well. I have medical emergency, my lord. Paying for the adjournment, my lord.
Okay. Same order. Outside the plane. 2 weeks.
2 weeks, my lord. I'm deeply aware.
My Lordship. Lordship, item 52 of supplementary list, my lord. I am paying to upgrade the same because person is in custody, my lord.
52.
52, my lord. My lord fixed it. It was fixed is last year, yesterday, my lord, but unfortunately, lord not listed.
Okay.
And declare.
May it please, your lordship. Lordship, back to mention item number 21, lordship. Matter may pass over for the day, lordship.
21.
21, lordship. 2 weeks time may be granted for conducting the hearing, lordship.
Pardon me?
2 weeks time may be granted, lordship, for conducting the hearing, lordship. 21.
You want to argue for 2 weeks?
No, just 2 weeks time may be granted.
Okay. Okay.
Obliged.
Yes.
May I please, your lordship? Also, back to mention item number 12, lordship. Lordship, there are some fundamental errors in the drafting, lordship, and we have to annex another some documents, lordship. That's why we want to withdraw with the liberty to file fresh, lordship.
Okay. Your name?
A. Mena, lordship.
A. Mena.
It's reflecting a visit.
Mr. A. Mena, under counsel for the petitioner submits that there's some typing error in the petition and vital document could not be annexed. So accordingly, he prays for liberty to withdraw the writ petition and to approach the court again. Next, all the respondents are represented. Prayer is allowed. Next, prayer is allowed. The matter is dismissed from withdrawal with liberty to approach again.
Obliged, lordship.
May I please, your lordship? I wish to mention item number 6, ma'am. I have some personal difficulty today, my lord.
You want an adjournment?
Fine.
Of when do you want?
After 2 weeks, ma'am.
Okay, same.
Obliged. Please, lordship. I beg to mention item number 30, lordship. May I adjourn this?
Item
30.
30.
30. May I adjourn this matter for the day, lordship?
Okay,
Master, please.
30 adjourn. 2 weeks.
Please, lordship. Lordship, I beg to mention item number 32, lordship. In this case, lordship, LC was called for, but that has not been received. The petitioner, she was also declared as an Indian, lordship. Both this case record were called for, but that has not been received.
Okay. That's it. Just check it up. Email address of notice we have. Email address will give us a record too.
You check the records.
32.
Yeah.
Okay.
You check. Yeah.
Ms. S. Das, learned counsel for the petitioner, has submitted that she has seen the records and the
Which
2
district? No.
records of the concerned tribunals were called for, which has not been received. Next para. All the respondents are represented. Next para. The registry shall issue a fresh reminder to the concerned tribunal to send the records of, write it, write the case numbers and give it.
FT case number?
No, don't say it orally.
Not-
Write it and give it, court master. For the following two cases. And the following email addresses of this said learned tribunal. Next for that. The learned member of the concerned foreigners tribunal shall send the records if or alternative scanned copy of the records can also be sent to the registry. Next for that list on 30/5/2025. Okay.
Applause, Lordship.
Maybe, Lordship, I beg to mention item number 29, Lordship. Lordship, senior counsel is out of session, Lordship.
Which council?
S.A. Sigar, item number 29.
There was something in this item 49. Just
29.
wait for some time.
29, Lordship.
29. Okay. Okay, 2 weeks. 29. Okay.
Oh, nice.
May I please, your lordship. Lordship, I beg to mention item number 37, my lord. 2 weeks time may be granted, my lord.
It is
Hello. May I please, your lordship. I beg to mention item number 53, my lord. In this case, I have filed an IA for correction and amendment of first title, my lord. Matter may be taken, my lord.
You want to update?
Update.
Daily list item 1 for motion.
May the lordship. In the item, my lord, we are required to file an affidavit, lordship, regarding the name mistake in affidavit, lordship.
Order dated 22/11, Lordship. You find it?
Sorry,
your name?
Yes, I Talukdar.
Mr. S.I. Talukdar, learned counsel for the petitioner. Praise for granting some time to substitute the affidavit
Lordship.
filed in support of the writ petition. To file a fresh affidavit in support of the writ petition. So the prayer is allowed. Next para. In the event a fresh affidavit is filed, same shall be tagged with record. Full stop. However, the affidavit which is currently available at para 25 shall be retained in record with a office note of the affidavit being substituted by a new one. Next para, list as and when the said affidavit is filed.
Item 2.
Yes, what is your best document?
My lord, this document is, my lord, one is, my lord, 1971 voter list in the name of parents of the
No, don't show us voters list. That's not a
Yeah.
good document.
document, my lord. Then, my lord, page 51, my lord. Page 51, my petition, my lord. That is the, my lord,
Which page is the opinion?
opinion page, my lord. 129, my lord. one 32, my lord. 132.
132.
Yes, my lord.
This appears to be one of the very good orders I have read. The opinion is really well written.
Yes, Lordship. Not to be deported, Lordship. Lordship may pass orders not to be deported since Lordship is taking it up for hearing soon, Lordship.
And in this case, my lord, since 1928-30, my lord, our father's name recorded in the, my lord, land documents, and thereafter, my lord, in all the voter list, my lord. And there is also, my lord, sufficiently, my lord, prove the linkage also, my lord, by calling the Latmondol and the, my lord, Gaubura. It is, my
This is so well written that we don't find fault in any part of this opinion. Number one, all your evidence is washed away because of the fact that number one, there are 5 shiftings of your family within a short span of time.
And 2 places burned.
That's one. Second is that you exhibited the Jamabandi to show a link with your father. But incidentally, in your pleadings, you have given two places of birth. One man cannot be born at 2 different places at different point of time. And therefore, you also say that in the same village you have land, but you have not yet mutated in the name. So therefore, the link is not there. Everywhere there's a gap in the link.
My lord, in fact, my lord, I have stated in my lord written statement as well as evidence in my lord. She was born, my lord, at one place, my lord. It is not stated at 2 places, my lord. But there is, my lord, almost 3 shiftings, as because, my lord, the erosion of my lord river Beki, my lord. They are nearest, my lord, adjacent village, my lord. One is, my lord, Safakamar, and my lord, adjacent village is Domni, my lord, and another is, my lord, Pop Safakamar.
You come to paragraph 12 of your written statement. You say in your written statement, paragraph 12, that she was born sometime in 1967 at village Gamari Guri. Again in 20, you say you were born sometime in 1967 at village Uttar Safa Kamar. Definitely, there's no link with your father if you were born twice.
My lord. My lord, pardon, my lord, para, my lord.
Oh, para 12 and 20. I don't expect us to know more than you.
My lord.
See para 12 and come to para 20. Therefore, everything is washed away.
Most probably, my lord, there was some typographical mistake. Otherwise, my lord, my lord,
It's a long time to find out.
This Uttar Safakamar, my lord, and my lord, there's a village.
No, you see,
my lord, Kamariguri, my lord.
I personally don't have any
Yes,
idea.
Yes, my lord.
But
lord.
but nonetheless,
Yes.
if I was born in Guwahati Medical College and Hospital, I can't say I was born in MMCH hospital just because they are very close by. 4 kilometers here and there, you come to MMCH. Or we
Except
turn out, if we come out from medical college, you can't say you are born in MCare. It may be very close, NXA. But still a place is a place.
My lord, I may be, my lord, granted bail, my lord, and
Lordship, all these things we can take up during hearing since Lordship is granting bail now.
No, he doesn't want bail.
No, that's what I fail to understand. Is getting relief is still arguing the matter.
No, you see, Ms. Verma, if we don't hear him, he will be aggrieved. He will go out and say that I am ready for arguing and the court is not hearing me and granting bail.
I'm sorry,
fixing
my
it for
lord.
hearing on some other day.
Well, I'm sorry, my
He'll
lord.
be aggrieved.
Last time,
You have already
No,
got
my lord,
relief for some time now.
yes, my lord, sir.
But he'll be aggrieved, Ms. Verma.
I understand, Lordship, but the list is very long today.
Had Mr. S. A. Ahmed, then counsel of the petitioner, and respondents are there, Mr. Islam on behalf of A. Ali. Finding this repetition under Article 226 of the Constitution of India. Order is at page, opinion is at page 132. opinion dated 26/5/2022, passed by so and so in so and so.
Next week to লিখে দিবা hearing objected division.
Case number so and so, in that page 132, I'm underlining, there's an IMDT case reference. Just add that also.
আজই এখন এটা
Be arising out of IMDT case number so and so. No? Which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next paragraph, pursuant to order dated 10/4/2025, the records of the tribunal is received. So accordingly, the court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. To stop, however, requisite extra copies of the petition be served on the learned CGC, State and Departmental Council within 2 days. Next para. The prayer for bail is opposed by the learned standing counsel for the FT matters. Next para. Considering the projection made in this writ petition, the court is inclined to grant bail to the petitioner. 10 days time to take bail. All of this 5,000 to the satisfaction of
SP Borpeta.
SP Border
Borpeta.
Borpeta. Release the matter for hearing in the first week of June 2025.
Obliged, my lord.
Item 3,
May I appeal your lordships?
Which page is the opinion?
Page 34, your lordship.
What is the best document you have?
Your lordship, if I have to say about the good document, in the year 1966, the name of the father of the petitioner has appeared, which is in page 106, your lordship. And then 109, where the name of the father and the mother has appeared, which is for the year 1970, your lordship. But subsequently, your lordship, the father of the petitioner died, and her elder brother name has appeared along with her mother, which is in page 1010, your lordship.
Is any voter list available with the entire family?
Entire family is not there, your lordship, but only the document is available is the 1985 voter list, your lordship, where the name of the mother and the elder brother has appeared.
Which
is
page?
Page 1010, your lordship.
One 107.
No.
No.
1011, your lordship. 111, your lordship. Khobiron Nessa is the mother. Jamaluddin is the elder brother, your lordship, who also has deposed before the lower.
No, any voter list which can show us the relationship or any other document showing the relationship. You claim that he is your brother.
Your lordship.
But there must be some document with your brother or mother or brother or father. So
Only one document that has been submitted, Your Lordship, as a linkage document, that is the Gambura certificate, Your Lordship, which is at page 139, 140, Your Lordship. Only Gambura certificate, Your Lordship. And the elder brother, who also deposed before the lower court below, Your Lordship, as DW2, Your Lordship.
140 carries no meaning because it has the state emblem.
Yes, Your Lordship.
Then the only reliable document is 145.
Yes, Your Lord. Your 145 is not the linkage document, Your Lordship. Is this a document which she has inherited from her husband, Your Lordship? That we have corrected, Your Lordship, with the permission of this honorable court. $145 is the Panchayat certificate, Your Lordship. Only.
But actually, we don't find any link document. The Gambura came and deposed.
Yes, Your Lordship.
He says that he maintains a population register, but he did not bring it and prove it.
Yes, Your Lordship.
So and he does not know the family because he does not know the name of the sisters. Where is your written statement?
Written statement is at page, Your Lordship, 42, Your Lordship.
Have you introduced your family here in the written statement?
Yes, Your Lordship. In para 14, Your Lordship, page 44, Your Lordship. 12, it's about the grandfather and mother, and 14 about the siblings, Your Lordship.
But you know, your brother,
Yes, Your Lordship.
he has absolutely demolished your case. I'll show you why. Come to page 44, paragraph 12.
Yes,
You
Your
have
Lordship.
showed us, this is your written statement,
Yes, Your Lordship.
para 12.
Yes.
Please read that.
That the second party's grandfather name was Darvesh Ali, alias Darvesh. Parents' names were Abdul Jalil, alias A. Jalil, alias Jalil, and Khobiron Nessa, alias Jomiron Nessa Beba, alias Mamoron Nessa, Your Lordship.
Now look at your beautiful brother. Come to page 85. That is the evidence of your brother.
Yes,
He's your brother, right?
yes, Your Lordship.
Now turn over to the next page. I do not know who Mamoran Nessa is.
Yes, Your Lordship.
Then
The actual name of the mother was.
no, we don't know. You see,
Yes.
Proceedings says my name of my mother is Mamoran Nessa. Brother comes and says that who is Mamoran Nessa, I don't know.
Yes. The actual name of the mother is.
No, wait. You see, I am not personally aware of the name.
Yes, Your Lordship.
You showed me the document and I am reading it. Had you not shown that, I would not noticed it.
I know, your lordship, there are lots of discrepancies in this case, your lordship, but the petitioner is a 67 years old lady, your lordship. And
67.
yes, your lordship.
Is it? Where I said it. But your proceeding is a modern lady. She's just like what you call the present fast food culture. You have something to top up with every fast food. You take a pizza, you top up with something. You come to page 44. My esteemed sister has found out toppings in your case. You have come to 44.
Yes.
Read para 14.
Yes, your lordship. That the second party has one brother, namely Jamaluddin, and four sisters, including the second party, namely Khudija Begum, the second party, Jahanara Khatun, Momtaz Begum, Sahira Begum, and Ramisa Khatun, and all were born at village
So
Hajipara.
therefore 4 plus 1, 5. This is the top up.
Yes.
There are 4 sisters and you name 5.
Five siblings, your lordship. One brother and four sisters, your lordship.
Again count. These names are there. Count again. One
Yes.
is second party including Khudija Begum.
Yes.
Khudija Begum is 1. Jahanara is 2nd. Mumtaz is 3rd. Saira is 4th.
Yes.
And I top up by Ramisa.
Khudija is the petitioner itself.
You
Then
read your own statement. I've read it.
four sisters. It's not. It includes herself as well, your lordship. She mean to say
You
that.
don't know this. Your English
Yes, your lordship.
is
It's-
not the dictation of both of us. Yeah.
Yes, your lordship. It
Then
could be three sisters, your lordship.
we don't know. I said that you said that you wanted bail because she's 67. We found out that she is quite modern.
No, your lordship.
If here we give bail, Mr. Sharma would not like it.
Lordship.
Okay.
Short death may be fixed, Lordship. Lordship may hard the method. Lordship.
Okay. Ms. Antekar and counsel for the petitioner. Respondents are there. Mr. Islam on behalf of AIB. Opinion is at page 34. 18/1/23 passed. So and so and so and so. IMDT reference number is there. Declaring the petitioner to be a foreigner post 25/1971 stream. Notice extra copies within 2 days. But make it a rule. Extra copies within 2 days. The records of the tribunal is received. Pursuant to order date 9/4/2025. Next para. Prayer for bail is opposed by the learned standing counsel for the FT matters. on the ground that though the petitioner in a written statement has referred to an alias name of her mother as Mamaran, Maran, Nessa, Nessa, but his brother who deposed as DW2 expressed his ignorance as to who Mamaran Nessa is. Full stop. It is also submitted that in paragraph 14 of the written statement, though the petitioner has pleaded that she has 4 sisters and 1 brother, including herself. No, 1 brother and 4 sisters, including herself. But she had named 5 persons as a sister, public siblings. It is also submitted that there are several other discrepancies for which the tribunal did not find the evidence to be reliable. Be that as it may, in view of the projection made in the petition, court is inclined to grant bail to the petitioner, namely so and so, on consideration that she is projecting herself to be 67 years of age. 10 days time to take bail. To the satisfaction, rupees 5,000 to the satisfaction of
SP Borpeta.
Police border Borpeta. Next, this is the matter for hearing. First week of June 2026.
Deeply obliged, Your Lordship.
Item 4,
Yes, so first thing, it's bail termination. Have you put notices on both the 2 references here? You have not 2 references?
Ms. Burma,
Yes,
in this
Lordship.
case, I have not checked both the records. There are 2 records. I did not check it.
Yes,
You
Lordship.
kindly see it. We'll take it up after some time.
Yes,
Because he's saying that there are 2 proceedings
2
drawn up.
separate references, exactly, that's what I was asking him, Lordship.
Please go through the records. I have not checked up. After some time, let her go through.
ये record to side है. ये तो note भी बना दिया. Pass number 9. Pass number give sir.
item 5,
May I please, Your Lordship? Lordship, this is a contested case and the impin opinion at page number 82, Your Lordship. The 8 pages opinion, Your Lordship. The relevant portion is at page number 19, paragraph number 16, Your Lordship, the observation part, Your Lordship. Page number 90, Your Lordship.
90.
Your Lordship. Paragraph number 16, Your Lordship.
There's no 90 here. Last page in our brief is page 89.
Item 5, Lordship. This is Mohammed Abdullah.
Yes.
No, I have up to 91.
It's 91 is there, your lordship.
91
Last
is
page
the
is
last page.
91, your lordship.
So Lordship, let her give a correct petition. Lordship will take it up then.
Check it out. Where
Lordship,
is-
lordship.
what has happened? Just check it out.
I'm not instruction, only go receive it. Okay. 94.
Item 7.
Lordship, item 7, extra copy has been served on us today, so Lordship will need some time to obtain instructions. We were asked to obtain instructions, Lordship, on 9/4. But copy has been served to us only today.
So we take it up next Wednesday. We take it up next Wednesday then.
It will be too early, Lordship. We'll need 2 weeks' time, Lordship.
Also is a representative. Ms. A. Verma, and its standing counsel for the FT matters, has submitted that pursuant to order dated 9/4/2025. No, by order dated 9/4/2025, she was instructed to obtain instructions regarding issuance of notice dated 31/8/2024.
Order to lie on the last day of the
After the delivery of opinion dated 28/8/2023, in the case referred in the said order. However, it is submitted that the extra copies of the requisition will be served on her only today. Next one. Accordingly, we adjourn the matter. So as to enable the learned standing counsel for the FT matters to obtain instructions. Next, give a date after 2 weeks.
16th of May, 65.
All right.
Item 8.
The color pen rakhi hai apne.
Make this the lordship. Lordship, the petitioner herein belongs from the post-Rajbangshi community, your lordship. Earlier, she was declared as a foreigner, your lordship. Thereafter, she approached before this honorable court. She was granted interim protection, and that case is pending before this honorable court, your lordship. And your lordship, now another, your lordship, notice has been sent to her, your lordship, and thereafter, your lordship, she appeared before the tribunal, and she apprised the tribunal that already a case on the same charge is pending before this honorable court, your lordship. But that, your lordship, application has been rejected, your lordship.
Lordship, the earlier proceeding and this may be clubbed together, Lordship. Then we'll also know, Lordship, what is happening. Whether it's one and the same person or not, Lordship.
But the notice has been sent to me, your lordship.
Where is that order?
Your lordship, the impugned order, your lordship will find that order on page 27, your lordship, 4/10/2024. And the petition, your lordship will find on page 25.
Lordship, this order is of October 2024.
Lordship. Lordship, thereafter, your lordship, once or twice the matter came up, adjournment was taken. And then your lordship, this petition is filed.
You see, this is a trouble which you are inviting yourself. You have saved 5-10 rupees and that has costed you the straight petition. You have filed petition at Annexure 4.
Lordship.
Was it very costly affair to annex the or copy of the order of opinion?
And Lordship, page 27 is
Your
there.
lordship, your lordship, if your lordship move on to page 26, your lordship, he has written, your lordship, in para 5, the copy of the order dated 19/1/21 is passed by the Honorable Guwahati High Court in writ petition by so and so is enclosed herein. So maybe your lordship,
Where is that in page 20? The original copy is at page 20, Annexure 4.
Yes.
You have not given the page number. Or 25 is there, it's 25. Where is
26, your lordship, point number 5, your lordship.
26? No, that is High Court order.
Yes, your lordship.
High Court order, how can I reading a High Court order of, say, Kerala High Court, you present before me, I will understand what is the matter pending before the
High Court.
trial court?
Your lordship,
Please tell me, you have produced before the High Court order before the tribunal.
lordship.
From the High Court order, what will the tribunal understand about the opinion which has been given by a different tribunal at Sonitpur?
Your lordship, by the same tribunal, your lordship, I have met, your lordship, the case number and all has been mentioned in this, your lordship, in the petition.
Or this tribunal, what you call Foreigners Tribunal 7th,
Yes, your lordship.
Charidwar Balipara.
Yes, your lordship. Your lordship, that order is also annexed, your lordship. in
If
this
at
petition.
page 27, there is an order where the member has stated that there are two references. This, the one which notice has gone now, it has been forwarded by the election office. And the first one, we do not know if it's from the local police lordship. Page 27 order lordship today, 4/10/24 order, which my friend has not submitted lordship. Today is fixed for written statement for the last time. The proceedee is present today with step. The state council is present today, pursued the petition filed so and so, informing that the writ petition filed by the Honorable High Court is pending. So this case may be kept in abeyance, but the High Court has not stated this proceeding as per the order of the writ petition dated 19/1/2021. This case is FTDC case, which is forwarded by the election office in the matter of enrolling his name in the voters list. This case FT1 2017, which is a police reference case, and it is not sure whether the FT1 and FT1495 are the same person or not. So this petition is rejected and this case will proceed accordingly. There is nothing wrong with this order, Lordship.
Your lordship,
No, but it can't. There cannot be two
No,
opinions.
Lordship.
You see, the tribunal cannot give two opinion, one in a police reference, one in an ERO reference.
So Lordship, we have to ascertain whether it is one and the same person. That is the reason I said both the writ petitions may be tagged and the records may be called, Lordship. We have to look into the inquiry report, Lordship, and the reference, how it has been sent to the tribunal. If it is one and the same person, then one proceeding can always be set aside.
Heard. Mr. I. Hussain, counsel for the petitioner. Also, all the respondents are there. Mr. Islam on behalf of AI Ali. Next. The case of the petitioner is that in a reference made against him, oh, sorry, her, it will be her,
yes, sir.
against her. An opinion dated 4/2/2017 has been passed by the learned member, Foreigners Tribunal 7th, Sonitpur Baripara, in case number, page
20, Lordship. Writ petition 79 of 2021.
the first opinion is page 13,
13, your lordship,
13,
FP
Lordship.
1 of
13.
17.
Page 13, so and so. Page put reference number so and so. Opinion dated is 16/3/2020. In reference to so and so. They were declaring her to be a foreigner of post 25/3/1971 stream. The said opinion has been challenged by the petitioner by filing WPC 79 of 2021. Thereafter, the petitioner has now been served with a notice dated 20 February 2024, issued by the these are two different foreigners tribunal or same foreigners tribunal?
Should be same, your lordship.
Hmm?
Your lordship, same, your lordship. Foreigners Tribunal 7, Balipara.
Another notice issued by the same learned tribunal. To appear in connection with FT case number capital DC 1495 oblique 2016 bearing SP within bracket border reference number TZP within bracket B 99/1407 dated 4/4/1999, page 22, requiring the petitioner to appear and file a written statement next paragraph. The petitioner entered appearance in this subsequent proceedings on 4/1/2024. Sorry, 4/10/2024. And filed a petition bringing the notice of the said learned tribunal the previous proceedings. However, by an order dated 4/10/2024, the said learned tribunal was of the view that the present reference was made by the border police no by the election by the election office. No, this is which is election case?
The fresh one, Lordship.
Freshman, no, you see the language at page 5, page
Last page.
27.
Yes, Lordship.
In the middle, it says, this case is FTDC case which is filed by election office.
Yes.
Again, he says this case FT1
Earlier case is police reference case.
earlier is police reference.
Yes, Lordship.
The present reference was by the election office, whereas the earlier reference was by the border police. And therefore, to ascertain as to whether the petitioner is the same person who had suffered the previous proceeding, the prayer of the petitioner was rejected, and the case was fixed on 12/11/2024 for written statement. So the said order, next paragraph, the said order dated 4/10/2024 is sent in this writ petition. Next paragraph. The learned standing counsel for the FT matters has submitted that it is the duty of the learned tribunal to examine as to whether the two proceedings are against the same person or not, and therefore, unless that satisfaction is arrived at, only second proceedings cannot be stayed. And accordingly, she supports the order dated 4/10/2024. Next paragraph. The court is of the considered opinion that the issue requires an examination. Next paragraph. Accordingly, the court is inclined to call for the scanned copy of the records of case number FTDC 1495 of 2016 from the Foreigners Tribunal number 7th, Tejpur, Balipara, to stop the registry shall send the requisition to the following email address of the said learned tribunal to enable the said authority to send a scanned copy of the order, a scanned copy of the records, to stop, however, comma, if facilities to scan and send the records are not available, the said learned tribunal may take the assistance of the Superintendent of Police, Border, Tejpur, do the needful. Alternative, the original records can also be sent. Next para. As the court is inclined to examine the matter, comma, the court is inclined to permit the petitioner to move an application for adjournment before the said learned tribunal, and the learned member, comma, Foreigners Tribunal number 7th, comma, Tejpur, comma, Balipara shall adjourn the matter. It shall adjourn the proceedings of case number FTDC 1495 of 2016 till 6/6/2025. Next para. Awaiting receipt of records, comma, list on 28/5/2025.
Lordship, this may be listed along with WPC 79.
So list this, so the registry shall also tag the records of WPC (79/2021). Okay, we are calling for the records on 28 May. We grant your prayer for adjournment for the tribunal till 6/6.
Lordship, can just put in a word, if the records of 79, this
No,
matter.
it would
Lordship,
have, otherwise he would have gone through the records. Maybe
maybe the records are
records are
here.
here.
Yes,
That's right.
I just thought so. Hmm.
Yes.
WPC 79, huh?
Yes, item 5.
My apology, there is some mistake in number in your lordship. I have corrected in my petition, your lordship. Now it was lordship in page number 88, your lordship.
Yes.
Paragraph 16, your lordship. It's the relevant portion, your lordship, the observation part, your lordship. Ninety to 88 rules.
Yes.
Here, your lordship, some minor discrepancies in the name of the projected father of the petitioner, your lordship, and grandfather of the petitioner. For that reason, your lordship, the petitioner have been declared foreigner, your lordship.
It's the perspective you have. It can be a blunder, it can be a discrepancy.
Now,
But
lordship, the lordship kindly, because here, your lordship, we have exhibited 13 documents, your lordship, in support of my case, your lordship.
you shows the you have presented a land document, sale deed and the Jamabandi.
Lordship.
Where is that?
Lordship.
Which page is that?
Lordship, I'm coming, your lordship. The Jamabandi that sale deed at page number 50, your lordship. Exhibit 8, your lordship.
Page number
50, your lordship.
50.
50, lordship.
Something is wrong. 50 according to here is exhibit 8. It's a sale deed.
Lordship.
Yes, it's a sale deed, your lordship.
Huh?
It was a sale deed, your lordship.
It's in vernacular.
It's a vernacular.
This is something I can't read.
There's some typing copies also there, your lordship. 49, your lordship. Relevant portion I have typed, your lordship. 49, your lordship. Then Jamabandi is also there, your lordship.
Yes.
Can you tell me this page 52 is related to which document?
Jamabandi, your lordship.
Page 52, 53.
Lordship.
This is related to which sale deed?
That was an old, it was a new one, your lordship. It was issued 30th March 2022. It was
You see, this is the only question we are asking for a simple reason. Come to
Lordship.
page 51. I hope you can read it.
Lordship,
Page 51,
Lordship,
Pata is 75
Lordship,
and Dag is 270 according to here.
Lordship,
Though overridden, we overlook that,
Lordship,
but this is what is it.
Lordship,
Now come to page number 53.
Lordship.
We don't have either Pata number 75 or Dag number 270.
Lordship. Yes,
That's why only one question we are asking.
Lordship. What happened otherwise, your Lordship, in my case, school certificate has been annexed, your Lordship, exhibited.
Where is that?
Yes, your Lordship.
You see, was the headmaster examined? No.
Examine, your Lordship. It was proved to your Lordship.
Where is that?
Lordship. I'm coming, your Lordship.
DW4, page 89, Lordship.
Hmm?
In page 89, OP DW4, Lordship.
That was at 67, your Lordship. The certificate, your Lordship.
Who is PW5?
PW5, the headmaster, your Lordship.
Huh?
Headmaster, your Lordship. OPW4 has been written here, your Lordship.
Five.
7, your Lordship.
Who is 5?
5 is the, your Lordship, from person 1 from register, your Lordship. Sub-register, your Lordship.
Right, it's in. এটা কোন নাম দিল?
One Jasnaram Sharma, your Lordship. It has been reflected at page number 87, your Lordship.
একটু আগত আহি আছে ইনটাজটো আছে তার নাম রবি ইনটাজ ইনটাজ
Just look at the index page.
Yes, Lordship.
Down below OPW 1, 2, 3, 4. 5 is not there and the court records 5 statement of 5. The tribunal records statement of 5.
Five evidence is there or not? I wanted to check that.
Otherwise,
You're welcome. It's
Lordship, now can I take the plea? It's a typographical error. The comment plea taken always, Lordship.
No, nothing on that, but
Maybe Lordship
Just-
missed out. No, but even the pagination doesn't shows.
we give a bail.
Lordship will fix it up for hearing also. Because the minor discrepancies are not minor. Maulobi, Imtaz Ali, Imtaz, and
No,
Yusuf and Ishaq.
It otherwise matches because if he
Yes.
held it also, he writes Molavi
Yeah. But only in the voters list, he doesn't write.
doesn't write.
because
Yeah.
that is
That may have been left out, Lordship.
no, not
It
left
is
because it
possible.
doesn't make a part of the name.
Yes.
It's just a what you call appendage to the name. Just like I will call you Miss Verma, and then and Miss is missing
Right.
in the voters list,
Lordship.
something like that.
Records are your Lordship can take it up, Lordship.
Ms. G. Boral and counsel for the petitioner. Respondents are there, Mr. Islam on behalf of AIRE. Page 82. Opinion dated 18/12/2024. Asked by so and so and so and so. Next person to
9 to dear.
the
Lo, bacha.
order dated 19/3/2025, the records of the tribunal is received. Court is inclined to issue rule returnable forfeit without requiring any press steps to be taken.
Because NRC.
However, requisite extra copies of the petition be served on the learned CGC, state and departmental counsel within 2 days. Next para. Prayer for bail is opposed by the learned standing counsel for the FT matters. Next para. Considering the projection made in this petition. Bail of 10 days time to take bail. The rupees 5,000 to the satisfaction of Supreme Police Border, Nogao. But your certified copy will be delayed. Deputy Commissioner will have to be changed. Superintendent of Police Border, you did not give the Mr. Nogao. Okay. Next para. The petitioner is read. Officer of incorrect description in as respond number 6. So accordingly, on the prayer made by learned counsel for the petitioner, she is permitted to amend the cause title and plead an appropriate authority as the respond number 6 by furnishing a type copy of the amended cause title to the AOJ FT section to be incorporated in the petition. Explanations of the certified copy of this order shall be delayed till the cost title is amended. Next para, list on. List for hearing in the first week of June 2026, 25. Your certified copy will be delayed. If you amend your
Lordship. Understood, no? You have to make it district commissioner.
Yes.
Item 9.
This is the lordship. This is the contested matter, lordship. Opinion page 54, lordship. This is 12/6/24. We grant him bail. But Mr. S.I. Talukdar, Learned Counsel for the petitioner. All the respondents are there, Mr. M. Islam for on behalf of AI Ali. Opinion dated 12/6/2024 at page 54. Passed by so and so in case number so and so, PE number so and so. Whereas the petitioner was declared to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks. Requisite extra copies of the petition be served on and CGC, State and Department Council within 2 days. Call for the relevant report from the concerned tribunal. Next paragraph. The prayer for bail is opposed by the learned standing person for the FT matters. Considering the projection made in this rate petition, the court is inclined to grant bail to the petitioner, namely so and so. 10 days time to take bail or rupees 5,000 to the satisfaction of SP Border Borpeta. Let's start with voice and visitor records.
Item 10.
Please also. You're challenging a 19 opinion now.
Lordship, not 19 opposition. Lordship, you kindly see, I have annexed page 33, the order.
Page
Page 33.
33.
Yes, Lordship. Lordship, I filed an application for adducing evidence of my brother as DW2. That was not accepted, Lordship. And the petition was rejected. Earlier, Lordship, I was declared foreigner, Lordship.
No, but that's that order is correct. Look at the previous the order of this court.
Yes, Lordship, that was.
This order is passed on 6/10/2023
Yes.
by this High Court in IS Civil 2994. Now your default is continuous. You got an order in the writ petition.
In 22 only, Lordship.
Yes.
6/10/2022.
For that, Lordship, I was allowed. My writ petitioner was allowed because on the day of election, the date was fixed. I could not produce appear before the learned tribunal as there is no transportation on that day. On that ground, my writ petition was allowed, and I was given a chance for cross-examination, Lordship.
Okay, that was an election day.
Yes, Lordship.
Okay. So after that, you were directed to appear on or before the 1910.
Yes, Lordship, I appeared. I am also examined, Lordship. Lordship may kindly see page 32. Page 32. I was examined, Lordship, I appeared.
After 1910-23, your examination was in 7/24, after 9 months.
Yes, Lordship. Uh,
Lordship, the order at page annexure 6, the members' order, Lordship, it clearly states, Lordship, as per order of the High Court, only directed to face cross-examination of OP and final hearing of the case. It cannot be an endless proceeding anytime, every time they want to bring in new evidence, new witnesses, Lordship. And if Lordship looks at the reference, I think it is the IMDT reference. How much more time they require? No direction order for filing new documents in this case. Considering the reasons above, the petition for filing new documents is hereby rejected. What is wrong in this order, Lordship? I just fail to understand. How many more years I must ask, does they need to prove their, bring in documents and prove the citizenship?
Only one opportunity, Lordship.
No, Lordship, no
My brother-
opportunity. Lordship, if opportunities are granted, sufficient opportunities.
If you
have
wanted
been
an
granted to
opportunity,
him.
you should have moved a review application of the order of the Honorable Single Judge.
No,
But
Lordship,
in this writ petition, we can't grant you that.
Lordship, we appeared, Lordship. We were allowed to cross
You come
examine.
to page 21, paragraph 10. Please
Yes.
read that.
Yes, Lordship.
From 22, he's seeking time again and again. Then we blame the tribunals for not disposing of the matters.
No, I have not blamed, Lordship. I have prayed.
No, no,
For the
you're,
tribunal and
it's a
tribunal-
general statement I'm making.
You can read paragraph 10 at page 21.
Yes.
Considering the entire facts and circumstances of the
sufficient-
case, we are of the opinion that it is a fit case to remand back the original case record of FT case so-and-so to the Foreigners Tribunal, Bongaigaon, and the petitioner should be given an opportunity for his cross-examination and also for final hearing of the case, where the petitioner stated that he had filed certain documents through additional evidence and additional written statement to prove himself to be a genuine citizen of India.
This is an order we can't touch.
What more, Lordship?
Pursuant to that order, we appeared, Lordship. I was also cross-examined, Lordship. May kindly see page 32, my cross-examination. On that day, I filed a petition.
You cannot file this. You do not have an order to
Let's just
file.
let him complete.
I filed a petition, Lordship, page 28.
Page 28.
Yes, Lordship. Praying to allow me to adduce evidence of my brother, Lordship, SDW2. And I want to produce one document, Lordship, showing linkage with my father and all other family members. That land document, Lordship, may kindly see at page 36. Page 36, my father and all other family members are there, including my name. I wanted to bring this document on record by through DW2, Lordship.
Why you could not produce it? Why you need your brother to prove your document?
Lordship.
But then you'll have to move the appropriate court. We can't allow it. This is an order we can't touch.
Paragraph
Yes.
12 is also
beyond our-
absolutely clear, Lordship.
It's beyond our jurisdiction to touch this paragraph 10.
That is our, Lordship. Pursuant to that order, we appeared, Lordship. Subsequently, we filed the petition, Lordship. That is rejected.
No, we understand. But you have read paragraph 10.
Yes, Lordship.
That misses the issue.
Subsequent petition was rejected,
No,
page
it's-
33. Therefore, Lordship,
Lordship,
correct
he-
petition of the
He's
court.
not,
No, please
he's pretending
Don't-
not to understand the order, Lordship.
don't. Once Mr. Hussain is there, we'll hear him and then come back to you. No, Mr. Hussain, we appreciate, rather we'll appreciate the tribunal in doing so. Sorry, this is a issue, we are dismissing it.
Lordship, question of citizenship is there. Therefore, I have approached this
No, no.
honorable court, Lordship.
You see, I would have been, we both have been, would have been so glad if we were given the appellate authority over paragraph 10 of this division bench order. Once we can't touch it, we can't modify that order to override that paragraph 10 with our own view. We can't express our view.
Lordship may kindly grant some time. I will apprise on some other date. Lordship may kindly.
No. Let's enter the matter. You have to take an adjournment, please take it at the first blush when we start the matter. Not halfway through it. Heard Mr. M.I. Hussain, learned counsel.
I
for
will
the
be allowed to
petitioner.
withdraw this petition. Lordship.
Okay. On the prayer made by Mr. M.I. Hussain, learned counsel for the petitioner, is permitted to withdraw this petition. Prayer is allowed. Next para. All the respondents are represented. Just give the names. So and so are represented. Next para, the prayer, the petition stands dismissal or withdrawal.
Obliged, Lordship.
Member of
We'll take a break and come back. In case number so and so, corresponding to our case number so and so, they were declaring the petitioner to be a foreigner of post 25/3/1971 stream. You should notice, call for the extra copies within 2 days, call for the records. Next para. The prayer for bail shall be considered on receipt of the tribunal's records. List on, give a date after 4 weeks. Give a fixed date or
2nd of June.
Item 13.
the 724 opinion.
his lordship. Lordship,
May please, your lordship.
record.
30, lordship.
Mr. F. Hassan, learned counsel for the petitioner. All the respondents are there. Page 47 is the opinion dated 1/7/2024. Passed by so and so in case number so and so. LVC number so and so. Declare the petitioner to be a foreigner of post 25/3/1971 stream. Notice returnable in 4 weeks. Call for the extra copies within 2 days. Call for the relevant records from the consent tribunal. It's for the prayer for bail is opposed by the learned standing counsel for the FT matters. Next, considering the projection made in this writ petition, comma. Bail of rupees 5,000 taken within 10 days to the satisfaction of
SP border looking for.
SP border Lakhimpur. Okay, list after 4 weeks on receipt of records.
Obliged, your honor.
Item 14.
I have to submit there.
Yes, Mr. Datta.
The
Where is the opinion?
opinion is page number 100 to 120, your lordships. It
Page
is a
number?
matter on remand. 100 to 126, your lordship, and extra 15, your lordship. 100 to 127. Opinion dated 13/3/2025. It's a matter on remand, your lordship. 100 to 120.
2020 opinion, lordship.
No, it's 25. It's a matter of remand.
Okay.
2020, then matter was remanded. Now what, where is the order of remand by this court? Where is that?
Annexure 10, your lordship, page 77.
77.
Yes, and the relevant portion is at page 79, your lordship, paragraph 4. Paragraph 4 and 5. Here, the report from the superintendent of police is not called for, your lordship. Only on the basis of the documents submitted by the petitioner.
Just a moment.
At page 79, paragraph 4 and 5, your lordship.
We are granting bail with respect.
Is outside your lordship. Updated.
So AM Dattar and Mr. AM Dattar and counsel for the petitioner. All the respondents are there. page 101, opinion dated 13/3/2025, passed by so-and-so in case number so-and-so, police reference number so-and-so. Comment declaring the petitioner to be a foreigner post 25/3/1971. It may be mentioned that by an earlier opinion dated 31/8/2020, the petitioner was declared to be a foreigner. However, on the matter being remanded to the said learned tribunal by order dated
26/6/2023.
Judgment order dated 19/6/2023. No, where is that order? High Court order?
I got order with that phase. 68 onwards, Your Lordship. Annexure 9. High Court order is page 77 onwards, Annexure 10, Your Lordship.
Opinion dated, High Court order dated 26/6/2023, passed in WPC 5238 of 2020, fresh opinion was rendered by the learned tribunal. Next paragraph. You should notice returnable in 4 weeks, extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Next paragraph. Prayer for bail is posed by the learned standing counsel for the FT matters. Next one, considering the projection made in this repetition and what is inclined to grant bail, 10 days time to take bail, 5,000 rupees to the satisfaction of Superintendent of Police Border, Morigaon.
Great locals.
Time being item 4.
Yes.
There are two separate cases, Lordship. Both the cases are clubbed together and finally disposed of together, Lordship.
Okay.
Tribunal come to the conclusion that, Lordship, both the persons are same person, Lordship, after making an inquiry, Lordship.
Okay.
Otherwise, there is no link, Lordship.
আগতে প্র্যাকটিক্যাল আগতে আরো প্র্যাকটিক্যাল
একটু যদি করেন আপনি
But what is the explanation for the delay? There's no explanation at all.
Yes, sir.
This there are 22 22
Paragraph
22 minutes. This 13 minutes.
financial crisis.
And
Tell me one man who does not have financial crisis.
and
Somebody will have financial crisis to purchase a BMW. Somebody may have financial crisis for not being able to purchase a Mercedes.
Lack of continuity is also there, Lordship.
Hmm?
Lack of continuity.
Lack of continuity. Okay.
You can, her father and grandfather also cannot establish her, could not able to establish her link, his link.
Any voter list of you along with your father,
No, no,
projected father? No.
Only Kabra certificate.
Or mother?
no.
No. And petitioner is only with her husband, my lord. In fact, my lord, father has filed evidence as well as deposed before the tribunal, my lord. And on
First of
Kabra
all,
also examined, my lord.
first of all, somebody must connect with the projected parents. Then you can examine the parents' evidence.
Got at the age of 18 years, my lord. Married. So, my lord, ultimately her name was appeared in the elector's roll.
Where is your first voter list?
Voter
Which page?
list. 26, my lord. Twenty-six.
Which one? Page
26.
26.
6 meters. Madam.
Any other document to link you to your projected parents?
My lord, the Kabul certificate as well as my lord, the secretary Kabul certificate, my lord. Is 32 as well as 34, my lord. 32 and 33. My lord.
How many witnesses were examined by you?
Not 3 Mailor.
Hmm? How many witnesses were examined by you?
3.
Who are they?
Petitioner's father, Mailor, GP secretary, as well as the Gabura Mailor. It is written in the Mailor order.
Petitioner examined herself.
Yes, Mailor.
Then petitioner's father.
Father.
Then
GP secretary, SCW1 and
Gabura.
And Gabura Mailor. Is 74 one hours.
Total 4 witnesses, 2 DWs and 2 CWs. Is 74 and 75 of the opinion lordship of the petition lordship discussed regarding evidence adduced by the proceeding lordship.
Was your father cross-examined?
Yes.
Well, we don't have that document.
Probably that will be in the LCR, maybe, yeah.
Huh?
That might be in the LCR, but in the 74th page, 71, it is then in the order sheet.
Okay.
Opinion. Yes.
Cross-examination.
Yeah, not cross.
Cross-examination. Yes, Lordship. Cross-examination.
Reject question petition. And documents are which into the $22 22 for 20 days, for the evidence it was from the last really jumping to this. So I have five given. You the yeah, copy that procurement. I will do to it. 23 to auto 23 to auto cross examination. Maybe that will get your yeah, I will face document.
We are not finding the cross-examination.
What's one? No proofs.
So what we have seen, we require that.
Deposition was recorded.
They have find evidence on affidavit lordship. I think what I have lordship mark lordship that was
Only deposition was recorded, not proofs.
as a deposit. Lordship may I have it? I may
We are giving it to you.
but presence of AGP was recorded in the opinion. Lordship.
Oh, hello. We got it. This 1966 voters list, whose names are there?
My lord, grandfather, my lord.
Then we have no case at all.
Yes.
Then you have no case at all.
My lord,
If 1966 and 1970s is your grandfather, then you have a very, very bleak case. And that is why perhaps your what you call the petitioner did not hand over to you the cross-examination of DW to your father. She has a reason not to give it to you. Just see this. Let's see. Mr. Sharma, look at the cross-examination. Look, it's in a pink flag. Because your father comes and says that he does not know your grandfather and grandmother. Second, he says that I have good relation with the Gambura and therefore certificate was given. The Gambura does not know my daughter. What else do you need? That is all your father says.
Talking about grandfather.
Grandfather, yes.
But his father's name was there with the voter list, my lord. 66. Azizul Haq's father, my lord. His name was there with him.
Okay. But you see, when you are exhibiting the voters list, voter list will have your father's name and then it'll have your grandfather's name also.
But it is Azizul Haq. Azizul Haq is the father of the present petitioner.
But that's why we ask you a specific question only. See, you see, we look at the record, we are asking just one question. We asked you that 1966 voter list contains whose name? You say it is the grandfather.
Grandfather of the petitioner.
Grandfather of the petitioner.
Right.
Grandfather of the petitioner's name, when it is there, it will contain his father's name also. Who is your grandfather?
Tanmir.
And then you say you don't know your grandfather.
Yes. Kazimuddin is the father of Azizul Haq. That is father of the city.
Look at
Tan
your
Mahmud- Tan
evidence,
Mahmud is
cross-examination.
there.
You
Yes,
don't
Tan
know your
Mahmud is there.
grandfather and grandmother.
Yes. Tan Mahmud is there.
Then,
Then Sasiful.
even with the document, you don't know your grandfather.
Azizul Haq.
It's not a good case for bail. You're not arrested.
No mind.
We will take it up next week for hearing. You're not in time to give you bail. Mr. S. Hockland, counsel for the petitioner, all the respondents are represented. Pursuant to order dated 9/4/2025, the records of the tribunal is received. Next point. In view of the nature of the nature of reply given by the father of the petitioner within bracket DW in his cross-examination, what is disinclined to grant bail to the petitioner at this stage, which will be considered considered at a later stage of this proceedings. Next paragraph. Issue rule returnable forthwith without requiring any fresh steps to be taken. So, however, repeated extra copies of the petition be served on the learned CGC, State and Departmental Council within 2 days. Next paragraph. It is the matter for hearing in the week commencing 28/5/2025.
Right.
We are keeping it open. You are not rejected your prayer. We are keeping it open. Let us hear the matter on week commencing 28th.
Right.
Just wait. Distinta matter silver bail. Second half years. Wait, wait. Pass it. That's what you know. Very good. Continue. Yes, item 15.
May it pleases your lordship. Impugned order is at page 30, Lordship,
30,
30, Lordship.
24 order.
Yes, Lordship.
Mr. Sharma, grant bail to the petitioner.
Lordship, I am there as a legal aid counsel.
As a legal aid counsel.
Yes, Lordship.
But Ms. D. Ghosh, legal aid counsel for the petitioner. Respondents are there, Mr. Islam on behalf of the Ali. Page 30 is the opinion, 5/7/2024. Passed by so and so in BNGN case number so and so. Reference PE case number so and so. Which the petitioner was declared to be a foreigner post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in this petition, court is inclined to grant bail to the petitioner, named so and so. 10 days time to take bail, rupees 5,000 to the satisfaction of
Bongaigaon, Lordship.
SP border Bongaigaon.
Respondent is.
Okay.
Supplementary item 46 for motion.
Which page is the opinion?
Yes, page 97.
97.
Yes. Twenty-one to 25.
21 to 25. Matter was remanded back.
Yes, ma'am. Lordship returned back Miller page 92.
Mr. A.M. Ahmed, counsel for the petitioner. Respondents are there, all of them. Opinion dated
Opinion dated Miller
21 to 2025, page 97. Passed by so and so. In case number so and so, FT case number so and so. There's also a memo number. Memo number so and so. Declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice call for the records. Extra copies within 2 days. Prayer for bail is opposed by the learned standing counsel for the FT matters. Bail rupees 5,000 to the 10 days to the satisfaction of SP border. Nalbari. Parties are correct.
Miller, I may be allowed to file an amendment cost title Miller in respect of Deputy Commissioner.
In respect of
In respect of respondent number 3. Here is Deputy Commissioner, District Commissioner.
I don't know, in our copy it is corrected.
Miller.
Correction, please. In our copy it is corrected.
Yes.
You give a proper copy to Mr. Sharma.
Yes. Yes, I'm good for
Okay. Satisfaction of which SP border? Nalbari. Okay. Yes.
Supplementary list,
Publish.
upgraded item 50 with 51 for orders.
Oh, this is a jail,
Yes, dinner.
the jail matter.
Yes. At room.
Okay. Not at 2. We'll take it up some other day because today at 2 we are proposing to start the
Laws.
APSC hearing.
Lordships. Any other term? I see. My lord, yes, yeah. Lordships.
Sorry, no.
It's okay, but since at 2 p.m. we are proposing to start that APSC matters.
Lordship.
It's keep this some other day.
Hello.
Mr. Mahmood, we'll fix this case after we complete after we pass orders in the APSC matters, because that may spill over from day to day. So ask some of your colleague to be here. We'll pass orders in this after the date is fixed in the APSC matters.
But just I have one submission. Here, Lordship has on the other day proposed to pass an interim order for interim compensation. And if Lordship is taking up the matter for the interim compensation
No,
purpose,
interim also as well as for that.
and
As well as we are hearing it on merit also, but interim order also we'll consider.
but or if Lordship passes an interim order, I leave it to your Lordship, or fix a date for final hearing. That can also do.
Okay, then we'll pass interim orders. We'll do it in the chambers.
True.
We propose to pass grant interim compensation of rupees 2 lakh.
That I leave it to your Lordship, and I leave it to your.
Okay, but still we'll pass orders after the APSC matters are there.
And in that case, I pray for a date after a week now.
Pardon me?
After a week now. For final hearing after a week.
After a week, okay.
Lordship.
Government
Since
somebody will be there, just remind me.
Since Lordship is passing an order for interim,
But I'll do so after I
But-
take up the APSC matters.
I-
Ask Mr. Sharma will be here,
Lord-
just tell him to remind me
But-
when I take up the matter.
Lordship.
Pass orders later on.
Lord.
Supply item 52. 52.
Interim order, page 103 of this petition. Lord, interim order of my writ petition is at page 103, my lord. On 6/3/25, on that day, my lord, petitioner appeared and he was taken into custody.
You write so many things, but in the first page, you don't write the date of arrest. Where will you find that? Where will you find it? The date of arrest, where have you stated?
My lord, that is.
Mr. Kondokar, we are post our lunchtime. We are spending time just because of you. Don't make us spend time unnecessarily.
My lord, 1 minute. my
Even you'll have to find out. No, we adjourn it. You find out and tell us next week. As the counsel for the petitioner is not prepared, list on Wednesday, 7/5/2025.
On 6th, my lord. 6th, my lord.
6 is, yeah, okay, 7th is a holiday. Okay, we understand. Then 9th May.
Item 53.
Page 45, I have stated.
But who's your boss? We just ask you one question. And we are telling you that we are spending our personal time with in your matter, just because.
I am playing apology, my lord, for that.
It's okay, we take up on that day. Be prepared. This is the only thing you have.
I am did.
My pleasure, Lord. My lord, in this case, my lord, on last occasion, my lord.
Just a moment.
Transfer করে ব্যবসা হ্যাঁ কেসটা ট্রান্সফার করে ব্যবসা করছে last week was Master of not have a decision. Initially case for us.
Yes,
In this case, on last occasion granted bail and directed the petitioner to appear before the SP Borpeta Board, my lord. He have went to the
you come after 1 year.
bail is already granted, my lord.
No, we understand, but if you don't, if this bail order is not implemented, you don't go there and appear before the Superintendent of Police.
We appear and they inform that the case record has been transferred to the SP Baksha, my lord. After creation of Baksha district. Initially,
But you see, you're again interesting. Now you'll have to amend your writ petition.
lordship.
You see,
First,
please, after drafting, please spend some time. You lead us to a situation where we have to, what you call, just overlook the uh, urgency in the matter. What is the date of the order which you want to modify?
my lord, 25/4/25.
25. Come to cause title page 1. Now, which is the order we want us to modify?
So, reply for the Mr. Point.
Typographical. So, you correct it. In view of the typographical error appearing in the cause title with regard to the date of the order in which modification is sought for, now we permit the petitioner to make necessary correction in the cause title in the presence of AOJ FT section. Thereafter, the matter be listed again.
Obviously.
Any matter left out? No. Updated matter any left out?
Item number 54 to 102, fixed at 2 p.m.
My lord, will kindly take item 57, my lord. That is the lead case. Fine. Starting from the graph. Made Pijalaks. My lord, yesterday I broadly indicated the 4 limbs of my argument, and I was harping on the last point, that is, my lord, whether in a 226 proceeding, statement made before the police or information contained in a case diary, whether it would be relevant for the purpose of the present proceedings. Now, as we all know, my lord, section 33, second proviso, clearly lays down the legal position very clearly that a statement
33 or?
Evidence Act, my lord.
Yes.
If your lordships would kindly come to the proviso, this second one, a relevancy of certain evidence for proving in subsequent proceeding the truth of the facts stated therein. I am covered by the second proviso, my lord,
that adverse party in the first proceedings had the right and opportunity of cross-exam. So, my lord, the statement made before the police is a one-sided game. That is why in the scheme of the Evidence Act, my lord,
But in this 33,
yes,
you will find evidence given by a witness in a judicial proceeding or before any person authorized it by law to
Yes,
take it
yes.
is relevant for the purpose of proving
Ah.
in a subsequent judicial proceeding
Ah.
or in a later stage of the same judicial
Just
proceeding.
there and kindly read the second proviso, second part thereafter. That whatever is said before the police officer, had he subjected himself to cross-examination, etc., in which case it would have been relevant. That is why it is said, my lord, if an information is relevant for the purpose of Evidence Act, then that information can be used in a Article 32 or a 226 proceeding. That is the proposition I want to advance, my lord, for your lordship's kind consideration. So there is a straight judgment of the Supreme Court, my lord. I'll rely on that. 1981, 2 SCC 493. 1981, 2 SCC 493. I'll rely on paragraph 3, my lord.
81 2 SCC 483
493, my lord.
93.
81, 2 SCC 493. If your lordship should kindly come to page 498, my lord.
Let us start quickly.
What's that? 16B.
Yes.
Yes. My lord will kindly come to page 498 on top. Sorry, the subpara. It bars the use of any statement made before a police
It will be
officer.
which paragraph?
My lord, it's part of para 3, my lord. It's a very long para. I'll have your lordship's kind attention to page number 498. Sentence starting with, it bars the use of any statement. In fact, my lord, first part runs into almost a page. Thereafter, my lord.
Yes.
Has your lordship's got it? Yes. It bars the use of any statement made before a police officer in the course of an investigation under Chapter 12, whether recorded in a police diary or otherwise. But by the express terms of this section, this bar is applicable only where such statement is sought to be used at any inquiry or trial in respect of any offense under investigation at the time when such statement was made. If the statement made before the police officer in the course of an investigation under Chapter 12 is sought to be used in any proceedings other than an inquiry or trial, or even at an inquiry or trial, but in respect of an offense other than which was under investigation at the time when the such statement was made, the bar of section 162 would not be attracted. This section has been enacted for the benefit of the accused. As pointed out by this court in Tahsildar Singh, it is indeed to protect the accused against the user of the statement of witness made before the police during investigation at the trial, presumably on the assumption that the said statements were not made under circumstances inspiring confidence. Then, my lord, the Tahsildar Singh is quoted. Then, are prepared to tell untruths and express its agreement with the view taken by the division bench of the Nagpur High Court in Baliram Tikaram Marathe versus Emperor, that object of this section is to protect the accused both against overzealous police officer and untruthful witnesses. Protection against the use of the statement made before the police during investigation is therefore granted to the accused by providing that such statements shall not be allowed to be used except for the limited purpose set out in the proviso to that section at any inquiry or trial in respect of the offense which was under investigation at the time when such statement was made. But this protection is unnecessary in any proceeding other than an inquiry or trial in respect of the offense under investigation, and hence the bar created by this section is a limited bar. Now this is important. It has no application, for example, in a civil proceeding or in a proceeding under Article 32 or 226 of the Constitution, and a statement made before a police officer in course of the investigation can be used as evidence in such proceeding, provided it is otherwise relevant under the Indian Evidence Act. This is the line I'm harping upon, my lord. So this information contained in the police diary would be relevant in a proceeding under 226 or 32 only when it is relevant under the Indian Evidence Act. So for this limited proposition, my lord, I have placed this judgment. Why I have placed this passage, my lord? Because Rule 20C mandates that a satisfaction has to be recorded by the governor that it is either unsuitable or whatever it is based on certain facts. So this police information, in my humble submission, is not even an information, not to speak of any inspiring any confidence. If it is no information, then what was the information based on which this satisfaction was derived? That misconduct part, that is another thing, I'll come to that. So basically, the basic ingredient required to attract Rule 20C is absent.
Can I ask you a question now?
Yes, Mr.
While you are in the Evidence Act, please come to the what you call definition clause C3, section 3.
Yes, what's
relevant.
Yes. One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to relevancy of fact. Yes.
Because you see, therefore, what is relevant is a subjective
some correlation, Milo.
some correlation. It is a satisfaction of the court as to what I would like to decide.
Yes.
And therefore we say that this is a fact which is relevant for the purpose of decision. In this case, we say it a point of determination. It may be issues framed or so and so forth. And therefore, it's a satisfaction derived at
yes
of the court as to what is the relevant fact. Therefore, these queries are put.
Yes.
Because then you'll have to also show us in course of your argument that this what you call the police report or whatever satisfaction this court had derived from the statement made before the police.
Yes.
Was not a fact which is relevant for the purpose of decision in this case. That's what you'll have to demonstrate in course of time.
In fact, I'll go a little further, Milord. It's not only that it is not relevant, it is no information. Because, Milord, what an information contained in the CD, it could not have furnished any basis to the governor to form the requisite opinion that this person is not either fit to be retained or that he is guilty of something, because that is not a proved fact. The fact must be proved fact. The fact must be established fact. Unless it is established or proved fact, then the requisite satisfaction cannot emanate. Well, this is my threshold argument, because in my humble submission, this para 7 in the writ petition, where the state candidly states that the basis for invoking Rule 20C is the information contained in the case diary. It is in that context, Milord, this is my threshold argument. So in my humble submission, Milord, this could not have formed the basis. And therefore, all subsequent actions are void ab initio. My lord, worse than the Assam case was the case of Punjab Public Service Commission. Now, there are two judgments of the Supreme Court, my lord, which I'll place now to show, my lord, why Supreme Court acted on the facts of those cases. What had happened, my lord, unlike a police report here, in the Punjab case, my lord, pursuant to the direction of the Supreme Court in the first case, that is Indrajit Kahlon's case, my lord, a three honorable judges of the Punjab and Haryana High Court constituted a committee. And based on the committee's recommendation, my lord, the grain was separated from the chaff. Here, my lord, had there been an administrative inquiry, I could have fined as well. But this police report could not have been. Now I'll place those two, my lord, judgment of the Supreme Court in that Punjab case. That is, first case is, my lord, 2006 11 SCC 356. 2006 11 SCC 356.
Paragraph
Paragraph 40, my lord.
40.
40. I'll rely upon 2-3 paragraphs, my lord. First, I'll refer to para 40. At page 383. We, as a lordship got it, yes. We at the outset would furthermore notice that having regard to the submission made by us, before us by Mr. Dwivedi and Mr. Rao, that the services of the appellants before us were terminated, not in terms of the rules, but in view of the commission of illegality in the selection process involved, we need not consider the applicability of the relevant provisions of the statutes, as also the effect of provisions of Article 3 and 11 of the Constitution of India. An appointment made in violation of Article 14 and 16 of India would be void. It would be a nullity. But before such a finding can be arrived at, the appointing authority must take into consideration foundational facts. Only when such foundational facts are established, the legal principles can be applied. My lord, there is no doubt that here was a case. The services were terminated not by invoking any provisions like the present case. Here, my lord, the entry into the service was construed to be unlawful. It was in that context. Therefore, the Supreme Court was concerned with what all are the, satisfaction which the authority must derive that to invoke such powers. Indirectly, in Assam case also, my lord, the argument which was made before the learned single judge, I find some similarity between the actions taken here. Now, para 41. If services of appointees who have put in few years of service were terminated, compliance with 3 principles at the hands of the state was imperative. To establish satisfaction in regard to sufficiency of the materials collected, so as to enable the state to arrive at its satisfaction that the selection process was tainted. 2, to determine the question that illegalities committed go to the root of the matter which vitiate the entire selection process. Such satisfaction as also sufficiency of materials were required to be gathered by reason of a thorough investigation in a fair and transparent manner. Whether sufficient materials present enable the state to arrive at the satisfaction that the officers in majority have found to be a part of the fraudulent purpose or system itself was corrupt. So, my lord, these 3 fundamental principles must be satisfied before the appointing authority can come to the conclusion that something was amiss in the selection process. Unless this satisfaction is arrived at, there can be none. Now here in this case, what is there, my lord? There is no administrative inquiry, no nothing, only some information contained in the case diary. Nothing else. Because state's affidavit para 7 is very explicit. Then my lord will kindly come to paragraph 42, my lord. Once para 42, my lord. Once such findings were arrived at, all appointment traceable to officers concerned could be cancelled. But admittedly, although there had been serious imputation against Sidhu, being at the helm of the affairs of the commission, all decisions made by the commission during his tenure are yet to be set aside. We do not intend to enter into the said controversy, as we were informed at the bar that the High Court itself is in session of the matter. We may, however, note that Mr. Dwivedi in his usual frankness stated that there may not be answer to that query. Apart from inferences drawn on certain facts, and in particular the circumstances enumerated by the High Court, which has been repeated by the learned counsel for the state before us, it is difficult to accept that it was demonstrated by the state that it was absolutely impossible for it to separate the innocent people from the tainted ones. So, my lord, this observation is in the context of whether the grain can be separated from the chaff. It is also not a case where all relevant records have been destroyed. The Vigilance Bureau does not say so. Question papers, answer sheets, and other documents are available. Reports made by the Bureau were prepared upon examination of the materials collected by it. The High Court itself has noticed that what is not available in the records relating to procedure adopted in regard to appointment of paper setters. It may be true that such record could be destroyed only after a period of 5 years, but it has not been pointed out by the state as to how, by reason of non-availability thereof, it became difficult for the authorities to arrive at the correct facts. We have not been informed that the connecting materials were also destroyed. It has been noticed by the High Court that all the relevant information was available and submitted to the court. It cannot therefore be said that a fair investigation into the whole affair was impossible task, or despite availability of such record, a thorough investigation has been made so as to arrive at a satisfaction that entire selection process suffered from a large-scale fraud. It has also been found that all appointments were made on extraneous consideration, including monetary consideration. If fraud in the selection process was established, the state should not have offered to hold the reselection. Seniority of those who were reselected ordinarily could not have been restored in their favor. Such an offer was evidently made as state was not sure about the involvement of a large number of employees. Distinction, moreover, exists between a proven case of mass cheating for a board examination and an unproven imputed charge of corruption where appointment of a civil servant is involved. Well, these observations are really in the context of whether it is possible to save some appointment instead of, cancelling all. Then my lord will kindly come to paragraphs 90, my lord. Now, I'm reading the part of the majority judgment, para 90 at page 399. The High Court was probably enthralled by the media reports that 2 of the wards of a sitting judge obtained appointment wrongly. It is, however, stated at the bar they were toppers of the batch, and in the first information report their names had not been mentioned. Only because of wards of a sitting judge obtained employment, same by itself would not give rise to presumption that everything was not well in the selection-making process. We, having regard to the peculiar facts and circumstances of the case, are of the opinion that it is necessary to direct consideration of the matter afresh. We have not been apprised whether in the criminal case any further material has been gathered as to implicate the appellants before us. We were, however, told that some of the new appointments have been made, effect whereof would certainly be subject to the decision of this court. We, however, do not intend to set aside the said appointments at this stage. We also do not intend to disturb the status quo. We must, however, express our satisfaction that no candidate for the year 2011 has been appointed. It is one thing to say that having regard to the nature of the selection, no person is appointed from the select list, as no person has a right to be appointed only because his name appears in the select list. But in our opinion, a different standard must be adopted for terminating the services of the officers who had completed about 3 years of service. Some of them, as noticed herein above before, passed departmental tests. Some have been given higher responsibility. They had completed the period of probation, and some are nearing completion thereof. They presumably had been working to the satisfaction of the authorities concerned. The impugned judgment, as also the orders of the state government and the High Court are set aside, are thus liable to be set aside, and directions are issued. Although the impugned judgment cannot be sustained, we are of the opinion that interest of the justice would be subserved if matter is remitted to the High Court for consideration of the matter afresh. However, with a view to segregate the tainted from the non-tainted, and that in the interest of justice, High Court should be requested to constitute 2 independent scrutiny committee, one relating to executive officers and other relating to judicial officers. Now, having laid down the Milord parameters which are to be taken note of to find out what are the sufficiency of materials, the impugned judgment of the High Court and the government was set aside, and matter was remanded to the government with a direction that 2 committees would be constituted, one for the executive and one for the judicial. Thereafter, Milord, the second judgment came. That is important in this case. That is, Milord, 2014 6 SCC 644. Yes. My Lord, 2014 6 SCC 644.
But you are conscious of what happened when our court did that exercise for that teachers' cases.
Yes, yes.
Then you know what happened.
Sadananda Haloi. No roving inquiry. Moral.
I'm glad you remembered that name. A lot of effort was put in.
Because I defended this election, Milord.
I know that. That's why I'm saying a lot of effort was put in that case.
Yes. I was on my friend's side then.
The right side.
Coincidentally.
I'm sorry, I couldn't resist myself.
No. Absolutely no problem. Lords will kindly come to para 10, Milord.
And the fallout is that still we have litigations relating to the same
Subject.
selection process.
My Lord, things ought to be better. There can be no doubt about it. My Lord, I am a professional. The briefest come, I'm arguing.
No, it's not that. We are not questioning your.
What I'm saying is, otherwise, not as a counsel representing the petition. Otherwise, my Lord, better.
We are not saying anything.
Yes,
We are
yes.
just looking at the ratio laid down here,
Right,
and then we are comparing it with what happened.
I, as a person, was trying to say something, and I'll not say, my Lord. Please come to para 10, Milord. Para 10 actually refers to Indraprit Kehlon's case, then para 10.1. An appointment made in violation of Article 14 and 16 of the Constitution of India would be void. It would be nullity, since the services of the appellants were terminated, not in terms of rules, but in view of the commission of illegality in the selection process involved. The applicability of the relevant provisions of the statute, as also effect of provisions of Article 10 and 11, need not be considered. My Lord, I must make one thing very clear, my Lord. These cases from Punjab, here, my Lord, interpretation of Articles 10 and 11 to never fail for consideration. Because it was not the case of the state or there in Punjab that they have discharged them. They say that your entry into the service was wrong. Therefore, we are setting aside your appointments. Here, my lord, the state of Assam stand is somewhere in between. Not very clear, my lord. 10.2. Before a finding that an appointment has been made in violation of Article 14 and 16 can be arrived at, the appointing authority must take into consideration the foundational facts. Only when such foundational facts are established can the legal principles be applied. When the services of the employees are terminated entirely on the ground that they might have aided and abetted corruption, thus either for the sake of probity in governance or in public interest, their services should be terminated. The court must satisfy itself that condition therefore exists. The court, while setting aside a selection, may require state to establish that process was so tainted that the entire selection process is liable to be cancelled. In case of this nature, thus, the question which requires serious consideration is as to whether, due to misdeed of some candidate, honest and meritorious candidates should also suffer. Then, Lord, please come to 10.4. Cases which may arise where selection process is perceived to be tainted may be categorized in the following manner. The cases where the event has been investigated, cases where severe inquiry took place and was completed or a preliminary investigation was conducted, cases where selection was made but appointment was not made, cases where candidates were also ineligible and appointments were found to be contrary to law rules. If the services of the appointee who had put in few years of service were terminated, compliance with three principles at the hands of the state was imperative. To establish to the satisfaction in regard to sufficiency of the materials collected so as to enable the state to arrive at a satisfaction that the selection process was tainted, to determine the question that illegality is committed went to the root of the matter which vitiated the entire selection process. Such satisfaction as also sufficiency of material were required to be gathered by reason of a thorough investigation in a fair and transparent manner. Whether sufficient material present enabled the state to arrive at the satisfaction that officers in majority had been found to be a part of the fraudulent purpose or the system. Once the foundational factual findings are as enumerated above are arrived at, or if it is found impossible or highly improbable to separate tainted from the untainted cases, all appointments traceable to the officers concerned would be cancelled. But admittedly, in the present case, although there had been serious imputations against Ravinder Pal Singh Sindhu being at the helm of the affairs of the State Public Service Commission, all decisions made by the Commission during his tenure are yet to be satisfied. Applying these principles to the facts of this case, the court in Inderpreet Singh Kahlon found that no candidate for the year 2001 had been appointed, and therefore persons were selected in that year were on a different footing. As merely a person comes in the select list, he has no right to be appointed on that ground. However, held the court, those who had already been appointed and had completed about 3 years of service, some of them had even passed the departmental test, and some were given higher responsibilities and even completed the period of probation or nearing completion thereof, and were working to the satisfaction of the authorities concerned. Different yardsticks were to be applied while terminating their service. As a matter of fact, court found that apart from inferences drawn on certain facts, and in particular the circumstances enumerated by the High Court, it was difficult to accept the contention of the state government that it was absolutely impossible for it to separate the innocent candidates from the tainted ones. Then my lord will kindly come to para 12, 1.1. If services of the appointees who had put in few years of service are to be terminated, compliance with the following principles by the state is imperative. Sufficient materials are to be collected, to be gathered by thorough investigation in a fair and transparent manner. Illegalities committed must go to the root of the matter. Appointing authorities appointees, officers in majority must be found to be a part of the fraudulent purpose or system itself must be found to be corrupt. In the present case, above principles not having been adhered, and since it could not be said that a fair investigation into the suspected selection to the Punjab Civil Service for the year 98 to 2000 was an impossible task, or despite availability of large part of the records, a thorough investigation had been made so as to arrive at a satisfaction that entire selection process suffered from a large-scale fraud, the High Court was not right in applying the principle of match setting in the instant case, an appropriate en masse termination service of the appellants. So, my lord, my humble submission based on these cases are, my lord, be it for adopting unfair means to enter into the service, or be it discharging a provisioner by invoking Rule 20C, these three tests must be fulfilled. And at least, my lord, whether any investigation by administrative authority was carried out is not indicated in the affidavit. All that is said is the information contained in the Tribunal police station CD is the only basis. So therefore, my humble submission is, my lord, it can be said that there was no material to attract Rule 20C. Here in this case, the judges' committee's findings are there. Now, my lord, will kindly come to paragraph 43, my lord. What had happened in this case?
The same Joginder Pal Singh case.
Yes, my lord. Joginder Pal, para 43. After remand, the writ petitions of these judicial officers were decided by the High Court in the case titled Sirandeep Singh Panang versus State of Punjab. The High Court had allowed those writ petitions. The said judgment of the High Court was challenged before this court in the High Court of Punjab versus so-and-so. This court, by means of the aforesaid judgment, upheld the decision of the High Court. The court specifically noted that after direction in the Indraprit Singh Kahlon, a committee of 3 judges was constituted, which undertook the exercise and submitted its report. This is what is important. Unlike a police report, in the case before the Punjab Police Civil Service case, my lord, 3 honorable judges committee inquired into the matter. And based on those findings, my lord, impugn action was taken. So, my lord, therefore, my humble submission is, these 2 judgments are not only authority for the proposition as to what all are the materials which alone could inspire the confidence of the authority to discharge a provisioner either on the ground of entering service illegally or for other misdeeds, my lord. Those findings must be arrived at, and those findings are not relevant. Now, my lord, having said that, I'll have to also satisfy your lordships that why I'm saying Article 311 is attractive. In these 2 cases, my lord, those situations did not arise because it was not the case of the state. They are invoking Article 311 violation was not gone into because the submission was that they have found that their entry into the service was wrong. Therefore, they have done it, which is not the case here. Therefore, my lord, I'll have to trace the law, my lord. First, I'll place that judgment of my lord Supreme Court in Purushottam Lal Dhingra. That is supposed to be the first case on the subject. Lord, Air 1958 Supreme Court 36. The position, page para 28, Miller. The position may therefore be summed up as follows. Para 20. Any and every termination of service is not dismissal, removal or reduction in rank. A termination of service brought about by exercise of a contractual right is not per se dismissal or removal, as has been held by this court in so and so. Likewise, the termination of service by compulsory retirement in terms of specific rule regulating the condition of Has your lordship got it, Miller?
Yes, yes, there's some technical problem with this.
Likewise, termination of service by compulsory retirement in terms of a specific rule regulating the condition of service is not tantamount to infliction of punishment and does not attract Article 311(2), as has been also held by this court in Shamlal versus State of UP. In earlier of the two above mentioned cases, the termination of the service did not carry with it the penal consequence of loss of pay or allowance under Rule 52 of the Fundamental Rules. It is true that misconduct, negligence, inefficiency, or other disqualification may be the motive or inducing factor which influences the government to take action under the terms of the contract of employment or specific service rule. Nevertheless, if a right exists under the contract or rules to terminate the service, the moving motive operating on the mind of the government is, as Sagla CJ has said in Srinivas Ganesh versus Union of India, wholly irrelevant. Now, this is important. In short, if termination of service is founded on the right flowing from the contract or service rule, then prima facie termination is not punishment and carries with it no evil consequences, and so Article 311 is not attractive. But if the government has by contract or under the rules the right to terminate employment without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reduction in rank, the government may nevertheless choose to punish the servant. And if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and requirements of Article 311 must be complied. I am on this method. If the rules permit, they'll do. But the moment you take note of misconduct or any wrongdoing on my part, then that is an subject of Milord. I mean, it's a fact. Therefore, there has to be an adjudication. And normally in service law, what you understand is a departmental inquiry. So, Milord, I could not have been discharged merely because there is some report in the some content in the Dibrugarh police station case diary. That cannot be enough. But that is an element of misconduct which was taken note of by the authority. So, my lord, since misconduct was the moving factor, therefore, in my humble submission, the compliance with Article 311(2) was an imperative. Next, my lord, I'll rely upon the Constitution bench of the Supreme Court in Samsher Singh, 1974, 2 SCC 831. (1974) 2 SCC 831. Paragraph 62 and 80. There is no dispute that we were probationer as far as ACS are concerned, my lord. As far as APS officers are concerned, I'll make that argument that they have completed their probation. Para 62 at page number 850. Has your lordships got it? Yes. Para 62. The position of a provisioner was considered by this court in Purushottam Lal Dhingra. Thus, CJ speaking for the court said, where a person is appointed to a permanent post in government service on probation, the trainee termination of his service during or at the end of the period of probation will not ordinarily and by itself be a punishment, because the government servant so appointed has no right to continue to hold such a post any more than a servant employed on probation by a private employer is entitled to do so. So, a termination does not operate as a forfeiture of any right of a servant to hold the post, for he has no such right. Obviously, such a termination cannot be dismissal, removal, or reduction in rank by way of punishment. Now, this is important. There are, however, two important observations of Das CJ in Dhingra's case. One is that if a right exists under a contract or a service rule to terminate the service, the motive operating on the mind of the government is wholly irrelevant. The other is that if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and violates Article 311 of the Constitution. The reasoning why motive is said to be relevant is that it inheres in the state of mind which is not discernible. On the other hand, if termination is founded on misconduct, it is objective and it is manifest. Then Lord will kindly come to para 80 at page 855. The order of termination of the services of Ishwar Chand Agarwal is clearly by way of punishment in the facts and circumstances of the case. The High Court not only denied Ishwar Chand Agarwal the protection under Article 131, but also denied itself the dignified control over the subordinate judiciary. The form of the order is not decisive as to whether the order is by way of a punishment. Even an innocuously worded order terminating the service may, in the facts and circumstances of the case, establish that an inquiry into the allegation of serious and grave character of misconduct involving stigma has been made in infraction of provisions of Article 311. In such a case, the simplicity of the form of the order will not give any sanctity. That is exactly what has been happened in this case of Ishwar Chand Agarwal. The order of termination is illegal and must be set aside. So, my lord, the principle which was affirmed by the Constitution bench was, my lord, whenever the termination of a probationer is founded on any allegation of misconduct, etc., or any other disqualification, then Article 311(2) is attracted, and therefore he is entitled to a inquiry. The termination could not have been done by invoking Rule 20C, which is a summary procedure, because my right under Article 311 read with Article 14 and 16 has been denied. Then, my lord, I'll rely upon 2-3 judgments on the same point. (1984) 2 SCC 369. I'm sorry. 1984 2 SCC 369. Anup Jaiswal. Yes.
You were referring to which case?
My lord, 1984
2 SCC
2
369.
SCC 369. Yes. Sir. para 11, 12 and 13. At page 378. এটা ফাইল লোৱা এটা জাজমেন্টত এটা অবজারভেশন পাবা যে এইটো কেছটো এই মানে On behalf of the Union of India, reliance has been placed on the state of Punjab versus so and so, so and so, so and so. We have gone through these decisions, except the case of Ramchandra Trivedi. All other cases referred to above were prior to the decision in Samser Singh, that's the Constitution bench, which is a judgment delivered by a bench of 7 judges. As pointed out by us in all these cases, including the case of Ramchandra Trivedi, the principle applied is the one enunciated by Purushottam Lal Dhingra's case, which we have referred to earlier. It is ours, relying upon the observation in Sri Sukhraj Bahadur case, that it is only when there is a full-scale departmental inquiry envisaged by Article 311(2) that an inquiry officer is appointed, a charge sheet submitted, explanation called for and considered. Any termination made thereafter will attract the operation of Article 311(2). It is significant that in the very same decision it is stated that circumstances preceding or attendant on the order of termination of service have to be examined in each case, the motive behind it being immaterial. As observed by Ray Cisse in Samser Singh's case, the form of the order is not decisive as to whether the order is by way of a punishment or that even an innocuously worded order terminating the service may in fact and circumstances of the case establish that an inquiry into the allegation of serious and grave character of misconduct involving stigma had been made in infraction of the provision of Article 311(2). It is therefore now well settled that where the form of the order is merely a camouflage for an order of dismissal or misconduct, it is always open to the court before which the order is challenged to go behind the form and ascertain the true character of the order. If the court holds that the order, though in the form is merely a determination of employment, is in reality a cloak for an order of punishment, court would not be debarred merely because of the form of the order in giving effect to the rights conferred by law upon the employee. In the instant case, the period of probation had not yet been over. The impugn order of discharge was passed in the middle of the probationary period. An explanation was called for from the appellant regarding the alleged act of indiscipline, namely arriving late at the gymnasium and acting as one of the ringleaders on the occasion of his explanation was obtained. Similar explanations were called from other probationers and inquiries were made behind the back of the appellant. Only the case of the appellant was dealt with severely in the end. The case of the other probationers who were also considered to be the ringleaders were not seriously taken note of. Even though the order of discharge may be non-committal, it cannot stand alone. Though the noting in the file of the government may be relevant, the cause for the order cannot be ignored. The recommendation of the director, which is the basis or foundation of the order, could be read along with the order for the purpose of determining its true character. If on reading the two together, the court reaches the conclusion that alleged act of misconduct was the cause of the order, and that but for that incident it would not have been passed, then it is inevitable that the order of discharge should fall to the ground, as the appellant had not been afforded a reasonable opportunity to defend himself as provided in Article 311(2) of the Constitution. But we never got an opportunity to defend our case. Merely because we are probationer, my lord, it does not mean that our service would be dispensed with merely on the basis of a police report. Then, my lord, will kindly come to the case of Palak Modi, which is very important. Now, this is Milord 2013 3 SCC 607. Two 2013 3 SCC 607. Now, apart from laying down the other principles, Milord, in para 36 of the judgment, what has been said is that if in the process of finding out, supposing, Milord, the appointing authority undertakes an exercise where they would like to find out whether these provisioners are suitable for confirmation or not. If in such an exercise or when such an exercise is undertaken, some shortcomings are noticed, maybe with regard to eligibility, maybe with regard to suitability, then if a simple order of termination is issued, then it will be considered as motive. But that is not the case here. Here the Supreme Court emphasizes on this. Therefore, this case is very important, Milord. Now, first, Milord will kindly come to para 25. Page 624. The ratio of the above mentioned judgment is that a provisioner has no right to hold the post and his service can be terminated at any time during or at the end of the period of provision or on account of general unsuitability for the post held by them. If competent authority holds an inquiry for judging the suitability of the provisioner for his further continuance in service or for confirmation, and such inquiry is the basis for taking decisions to terminate his service, then the action of the competent authority cannot be castigated as punitive. This is what I was submitting, Milord. Unlike this, here the exercise was to find fault with us, in us and to terminate. So if this would have been the case, and the records must reveal this. So in a certiorari proceeding, Milord, the respondents have a duty to produce the records to show, Milord, that and in fact an exercise of such a nature was undertaken. At least before the learned single judge, I don't think any such record could be produced. Moreover, if the allegation of misconduct constitutes the foundation of the action taken, the ultimate decision taken by the competent authority can be nullified on the ground of violation of rules of natural justice. Then Milord will kindly skip this. Please come to para 36. In the facts of this case, what view has been taken and what is the proposition of law that has been laid down. Para 36 at page 633. Paragraph 2 There is a marked distinction between the concepts of satisfactory completion of provision and successful passing of a training test held during or at the end of the period of provision, which are sine qua non for confirmation of a provisioner, and the bank's right to punish a provisioner for any defined misconduct, misbehavior, or misdemeanor. In a given case, the competent authority may, while deciding the issue of suitability of provisioner to be confirmed, ignore the acts of misconduct and terminate his services without casting any aspersion or stigma which may adversely affect his future prospect. But if misconduct, misdemeanor constitutes the basis of the final decision taken by the competent authority to dispense with the service of provisioner, albeit by non-stigmatic order, the court can lift the veil and declare that in the garb of termination simpliciter, the employer has punished the employee for an act of misconduct. Para 37. The use of unfair means in evaluation test, confirmation test held by bank certainly constitute a misconduct. So, Milord, Supreme Court went to the extent of saying that he adopted unfair means, or if one adopts unfair means, it will be construed as a misconduct. The bank itself had treated such an act to be misconduct. It is not in dispute that services of the private respondents were not terminated on the ground that there was any deficiency or shortcoming in their work or performance during probation, or that they had failed to satisfactorily complete the training, or had failed to secure the qualifying marks in the test held on 27/2/11. As a matter of fact, the note prepared by the Deputy General Manager, which was approved by the General Manager, makes it crystal clear that the decision to dispense with service of the private respondent was taken solely on the ground that they were guilty of using unfair means in the test held on 27/2/2011. To put it differently, the foundation of the action taken by the General Manager was the accusation that while appearing in the objective test, the private respondent had resorted to copying. IBPS had relied upon analysis made by computer and sent a report to the bank, and and that 18 candidates were suspected to have used unfair means. The authority concerned then sent for the chart of the cheating arrangement and treated the same as a piece of evidence for coming into the conclusion that private respondents had indeed used unfair means in the examination. This exercise was not preceded by an inquiry involving the private respondents, and no opportunity was given to them to defend themselves against the charge of use of unfair means. In other words, they were condemned unheard, which in our considered view was legally impermissible. The question is not a case very. Yeah. Now, my lord, internet. Now, my lord, this judgment is of utmost importance in our case for two reasons, my lord, in my humble submission, subject to what your lordships may say. First, if in a process where an attempting is being made to find out the suitability of an officer for retention, either at the end of the period or during the period of probation, some shortcomings are noticed or even some misconduct are noticed, then employer may say, there are misconduct, we will not inquire into it, at the same time would not like to retain them. But in that process, if you record a finding, that is okay. But the impugn order does not reflect that. So therefore, there is a question of lifting the veil, meaning thereby, lordship will have to go through the records. At least we argued the matter before the learned single judge, my lord. At least no records were produced wherefrom it could transpire that in the process of finding out suitability of a probationer, this decision was taken. On the contrary, para 7 of the writ petition, affidavit of the state is very, unequivocal when it says, my lord, that Dibrugarh police report was taken note of.
That was the basis.
That was the only basis. That means some allegation against us, some misconduct, something, some wrongdoing on our part. And secondly, my lord, my lord, even assuming the allegation is correct, what they are saying that our entry into the service was tainted, even then it is a misconduct. Then also we are entitled to a notice. So para 37, the first two sentence, the use of unfair means in evaluation test, confirmation test held by the bank certainly constitutes a misconduct. So therefore it was misconduct was taken note of, therefore Article 11 is attractive.
No, but
Now, my lord.
But I may read it differently, because what has happened here,
Yes.
there was first a probation entry in probation. Then there was a second entry for confirmation.
Yes.
And it is the misconduct during this test. So this is not a pre-entry misconduct which is being inquired into.
No, I'm on a slightly different point. My lord, yes, the facts in Palak Modi was slightly different. I'm not disputing that. What I'm saying is, my lord, because kindly permit me, my lord, let us see the learned single judge's order in this regard. Now,
Internal page 87.
87.
Para 46.
If your lordship would kindly come to page 280, my lord. Page 280, para 46 of the judgment. 280. 280 of the impugned judgment.
Para 46.
Para 46. 46. Yes. Now, please come to para 46, my lord, page 280. This is the finding of the single judge. Clearly, the allegation of irregularities on the part of the petitioners are not allegations of any irregularities, negligence, inefficiency, and misconduct taking place during discharge of their duties, post-recruitment, and after having been appointed to public office. The allegation against the petitioners in indulging in gross irregularities and fraud involving payment of illegal gratification for securing appointment to public service are apparently a pre-recruitment period, that is before they are appointed to public offices. In the understanding of this court, the element of misconduct which reverberates in the submission made on behalf of the petitioners is attributable only in respect of period subject to a valid initial appointment. Now, this is important. Not a single citation could be placed on behalf of the petitioners for the proposition that irregularities committed during recruitment process or before appointment had been made or before a person is born into a cadre would constitute misconduct. A vain attempt was made when reliance was placed on para 37 of Palak Modi to say that use of unfair means in evaluation test confirmation would certainly constitute misconduct. Reliance so placed vis-a-vis the facts and circumstances in the present case is altogether out of context. In Palak Modi, the private respondent therein had already been appointed as a provisionary officer way back on 2006. In due course, State Bank had informed that they were due for confirmation in service and therefore they are to appear in the test proposed to be conducted on 2027-11. The private respondent appeared in the test held on 27-11, but their names did not figure in the result declared on 10/5/2011, primarily on the ground that the Institute of Banking Personnel Selection, which body was entrusted with the task of preparing the examination paper and evaluating the answer sheet, submitted a report to the bank that some candidates, including private respondents, were suspected to have used unfair means. Thus, para 37 of the Palak Modi, which makes mention of the use of unfair means during evaluation, would constitute misconduct, was only in the respect of a test conducted for the confirmation is service. Now, law has laid down in Palak Modi that misconduct can also be stretched back to a period prior to entering into service and or irregularities and illegalities committed during the selection process. As misconduct cannot be a pre-recruitment phenomena, the very bedrock of submission made on behalf of the petitioner that the impugned action being founded on misconduct, therefore the principles of natural justice and provisions of 311 could not have been dispensed with in the considered opinion of the court does not hold any quarter. My lord, in my humble submission, my lord, this finding of the learned single judge is wrong on 3 counts. Firstly, my lord, it is not correct that we could not cite a single judgment which relate to pre-recruitment, phenomena where some allegations are attributed. Let us not confine it to misconduct because it says other qualifications, other disqualifications. So other disqualification would be very broad. Secondly, my lord, why Palak Modi is not an authority for the proposition that even in a pre-recruitment stage also misconduct would be a relevant consideration, and if it is involved, then Article 311 is attractive. And the distinction which has been made with utmost respect, I'll submit, is not correct, my lord. And not only Palak Modi, there are subsequent judgment. Ratneshwar's case, I'll place, where similar view has been taken. My lord, my lord, therefore, now it is not the case of the state in their affidavit. It is not the explicit case of the state in their affidavit that we are guilty of this. All that is said is that there is a police report which are suggestive of some wrongdoing at the entry level. Therefore, they have taken these steps. Now, my lord, to say that not a single judgment was cited, number one, is not correct. Palak Modi was cited. There's no question of Milok a vain attempt. When an authority is there, we boldly place it. Now, if your lordships would kindly come to line about 5 from the bottom of page 281 of the para number 46, the sentence starting with, as misconduct cannot be a pre-recruitment phenomena, the very bedrock of submission made on behalf of the petitioner has to fail. My lord, in a pre-recruitment stage, if a candidate may not be a provisioner on that day, if he resorts to a wrongdoing, why it will not be constituted as a misconduct? It will be a wrongdoing. And you are taking note of a wrongdoing. If you are taking note of a wrongdoing, then how you can dispense with the service of a provisioner without an inquiry? And that too after we have almost completed all the training and all. All of a sudden it happened. So therefore, my lord, eventually this is the conclusion, my lord. Then my lord will kindly come to para 47. We were inducted into service. It's not a case where they were caught red-handed while copying, as was the case of Palak Modi, my lord, as there were reports. Yes, if there would have been, well, the best thing for the government was to institute an inquiry by one of the secretary or by the commissioner or by the APSC itself. Instead, my lord, they have registered a police case. And based on the police case, they were moving around. How can police case information furnish a cause of action? That is the whole futility of the exercise undertaken. End of the day, lordship is deciding the decision-making process. We are not concerned with the merits of the decision. We are concerned with the manner in which the decision was arrived at to discharge us. Para 47. Indeed, there can be no hiding from the fact that the arrest and materials collected against the petitioners following the FIR and FIR dated 27/10/16 registered as Dibrugarh PS case number has set the ball rolling. And the first, my lord, the person, he has been reinstated in service. This first person, some Patir, Nabakanto Patir. We have a next document, my lord. Okay, asino ba ito? What will it do? Nabakanto Patir. What will Nabakanto Patir do? What? 20. And my lord, we'll place it, my lord. In fact, he was reinstated. Minister, no. Dibrugarh, yes. This gentleman, he was reinstated. We'll place that order. It is there in the record, my lord. Which eventually resulted in the impugn orders being passed, preceded by consultation with concerned department, obtaining the views of the judicial department and approval of the highest governmental authority. The impugned actions are only in the respect of identifiable group section of candidates who had appeared in the mains examination. The identifiable group are only those candidates where their duplicate answer sheets after substituting with their original seats were recovered from the confidential examination branch of APSC as well as from the House of Sri Chairman Rakesh Kumar Pal. The identifiable group alone were discharged from service against whom charge sheets have been filed. There are 52 writ petitioners herein and another 8 candidates who are not before this court. Allegations are with regard to criminal conspiracies resulting in tampering with examination process for the benefit of the petitioners herein. Investigations have revealed that petitioners had indulged in unfair. Oh no, what investigation? Police investigation. How could have learned single judge taken note of it? Is it germane? Is it a relevant consideration? So and so revealed that the petitioner had indulged in unfair means for getting selected by paying bribe or on extraneous consideration, but certainly not account of merit. There are cogent materials on which the respondent authority derives satisfaction that the selection process through which the petitioners came to be selected and eventually appointed was tainted by fraud. The illegalities in the selection and appointment of the petitioners being founded at the threshold itself, can it be said that state action was not bona fide? In that case, my lord, people will start filing suits before in 226. There's no requirement of proving any facts. If this proposition of law is to be upheld, my lord, then my lord, even civil suits can be filed in 226. If these materials form the basis, with all respect, I am submitting, my lord. There are causes, etc. So and so, so and so. Can it be said that it was not open to the state government to act on the disturbing revelations emanating from the police? Now, court itself says, emanating from the police investigation with regard to grave illegalities being discovered involving the petitioners during the selection process, which illegalities occurred before they had entered into service. To reiterate, the discharge of the petitioners from service was not on account of any alleged misconduct after appointment, but on discovery of fraud at the point of their very entry into service. There is a clear dividing line between challenge made to an order of discharge on the ground of misconduct during post-requirement period and a challenge made to an order of discharge on the ground of irregularities and illegalities finding place relatable to pre-recruitment period. My lord, I'll pause here for a moment, my lord. My humble submission is, if at a pre-recruitment stage you have to find fault, then you have to follow the dicta in my lord Indrapit Singh Kahlon and Joginder Pal. You cannot, based on a police report, take this action. There, 3 honorable judges of the Punjab and Haryana High Court inquired into the matter. They recorded finding based on which actions were taken. Here, other than the police report, there is nothing. Then, there is no requirement of conviction. A man will be presumed to be guilty. This is a dangerous proposition, my lord. This cannot be, I mean, with all respect, I will submit, my lord, this is not correct. Police Whereas the former would invariably invite compliance of odi alteram partem rule of natural justice and or compliance of the protection guaranteed under Article 311 of the Constitution, the latter can fall within the category of exceptions to the rule of odi alteram partem, particularly if there are reliable materials to reach a satisfaction insofar as the petitioners are concerned. The examination process and their selection was vitiated. Going back to Purushottam Lal Dhingra and Shamsher Singh, it is only when termination is seen to be founded on manifest misconduct, it would be punishment and will go to violate Article 311 of the Constitution in absence of an inquiry. However, as observed above, the argument of misconduct being the foundation are wholly misplaced and misconceived, inasmuch as discharge of the petitioner from service are not founded on the phenomenon of misconduct as is understood in service jurisprudence. with all respect, my lord, Purushottam Lal Dhingra and Samsher Singh never laid down any proposition as the learned single judge would like to, say, my lord. Absolutely not correct. On the contrary, Purushottam Lal Dhingra and Samsher Singh says what we are trying to advocate before your lordships. And my lord, kindly see this aspect, my lord. Now, kindly see the last sentence at page 282. Letter can fall within the category of exceptions to the rule of audio alteram partem, particularly if there are reliable materials to reach that satisfaction. Now, what are the materials? Is it the 3 judges committee report or some secretary of the Department of Government of Assam has constituted an inquiry? There are 2-3 cases where Supreme Court, my lord, where CBI has conducted a preliminary inquiry, not a my lord, regular inquiry. Based on preliminary inquiry report, actions were taken, Supreme Court upheld. But here, my lord, other than the case there is nothing. Now, the learned single judge is oblivious of the fact that there is a requirement of reliable material. Now, what is reliable material? What has been said by the Supreme Court in Indrapit Kailon? The police report could not have been. Now, para 48. Dibrugarh police report following investigation are part of the records, and a compilation of the same has also been furnished before this court by Mr. D.K. Mishra, Learned Counsel, Senior Counsel during the course of hearing. It is seen that illegalities and irregularities discovered in the selection has been scrutinized and investigated upon in respect of each of the writ petition. Detailed police investigation enabled to pick out the candidates who had unlawfully benefited. A mere perusal of the police report leaves no room for doubt as to the thoroughness with which the investigation was carried out. Irregularities attributed against each of the petitioners are minuted, reinforced by statement made before the investigating officer by such officer as available in the record, admitting to their complicity. Having gone through the police report, prima facie view of the court is that same commands itself for acceptance. So, my lord, this is only the police report which was taken note of by the learned single judge. So, this is the judgment, my lord. Let's go on. Now, next, I'll refer to, my lord, 2015 SCC 151. Ratnesh Kumar Chaudhary versus Indira Gandhi Institute of Medical Science. This is a judgment relying on Palak Modi's case, my lord. I'll rely upon 3 paragraphs, paragraph 25, 26 and 27. The ultimate ratio in Palak Modi is noticed by the Supreme Court in this para 25. And our humble submission is, my lord, the single judge's view is not correct. Because this is what Supreme Court has understood in what manner Palak Modi was decided. Please see, my lord, para 25. In Palak Modi's case, the ratio that has been laid down by the 2 judges' bench is to the following effect. The ratio of the above mentioned judgment is that a probationer has no right to hold the post and his service can be terminated at any time during or at the end of the period of probation on account of general unsuitability for the post held by him. If the competent authority holds an inquiry for judging the suitability of the probationer or for his further continuance in service or for confirmation and such inquiry is the basis for taking decision to terminate his service, then action of the competent authority cannot be castigated as punitive. However, if allegation of misconduct constitutes the foundation of the action taken, the ultimate decision taken by the competent authority can be nullified on the ground of violation of rules of natural justice. In the facts of Palak Modi, the court proceeded to state that there is a marked distinction between concept of satisfactory completion of probation and successful passing of training test held during or at the end of the probation period, which is sine qua non for confirmation of a probationer, and bank's right to punish a probationer for any defined misconduct, misbehavior, or misdemeanor. In a given case, the competent authority may, while deciding the issue of suitability of the probationer to be confirmed, ignore the acts of misconduct and terminate his service without casting any aspersion or stigma which may adversely affect his future prospect. But if misconduct, misdemeanor constitutes the basis of final decision taken by the competent authority to dispense with the service of the probationer, albeit by a non-stigmatic order, the court can leave the veil and declare that in the garb of termination simpliciter, employee has been punished, the employee for an employer has punished the employee for an act of misconduct. In the case in hand, it is clear as crystal that on the basis of complaint made by a member of Legislative Assembly, an inquiry was directed to be held. It has been innocuously stated that the complainant was relating to an illegal selection on the ground that the appellant did not possess requisite qualification and was appointed to the post of chest therapist. The report that was submitted by Cabinet Vigilance Department eloquently states about the conduct and character of the appellant. The stand taken in the counter affidavit indicates about the behavior of the appellant. It is also noticeable that the authorities, after issuing the notice to show cause and obtaining a reply from the delinquent employee, did not supply the documents. Be that as it may, no regular inquiry was held and he was visited with punishment of dismissal. It is well settled in law, if an expert inquiry is held behind the back of the delinquent employee and there are stigmatic remarks that would constitute foundation and not the motive. Therefore, when the inquiry commenced and therefore without framing of charges or without holding any inquiry, the delinquent employee was dismissed, definitely there is a clear violation of principles of natural justice. It cannot be equated with a situation of dropping of the disciplinary proceeding and passing of an order of termination simpliciter. In that event, it would have been motive but could not have traveled to the realm of the foundation. Now here in this case also, my lord, the case was that he was guilty of adopting unfair means. This kindly see, my lord, an inquiry was directed, it has innocuously been stated, the complaint illegal on the ground the appellant did not possess requisite qualification. So this was also a case which related to pre-recruitment, as the term has been coined by the learned single judge. So here also the Honorable Supreme Court has said, my lord, with all humility I'll submit. So the view taken by the learned single judge is perhaps not correct, my lord, and it needs a correction at the lordship's hands. Yes. My lord, if your lordships would now come to 2010 8 SCC 220. 2010 8 SCC 220 Union of India versus Mahabir Singhvi. Now it speaks of some life connection, the other facet of the first limb of the formulation. Mr. Bhushan submitted that as has been rightly held by the High Court, the case of the respondent was fully covered by series of decisions of this court, which have also been referred to on behalf of the petitioners. Mr. Bhushan, however, laid special
You're reading
emphasis
which
on
paragraph?
para 41 at page 231. Mr. Bhushan submitted that as has been rightly held by the High Court, the case of the respondent was fully covered by a series of decisions of this court, which have also been referred to on behalf of the petitioners. Mr. Bhushan, however, laid special emphasis on the following decisions of this court, some of which have also been cited on behalf of the petitioners, namely so and so, so and so, so and so, wherein it has been repeatedly observed if a discharge is based upon misconduct, now this is important, or there is a live connection between the allegations of misconduct and discharge, then same, even if couched in the language which is not stigmatic, would amount to punishment for which a departmental inquiry was imperative. Various other decisions were also cited by Bhushan, which reflect the same views as expressed by this court in aforementioned decisions. Well, we are not saying that we are not liable to face an inquiry. All that we are saying is, hold a regular inquiry, hold us guilty, dismiss us. We are not saying we are, immune from any inquiry. All that we are saying is, the manner in which the discharge orders were passed, it cannot be countenanced by law. You hold an inquiry. Yes. I'll just cite two more judgment, my lord, then I'll sum up here, then I'll go to the APS case. Now, next judgment is, my lord, 2013, 16 SCC 59. Registrar General High Court of Gujarat versus Joytri Chamanlal. 2013, 16 SCC, page 59, paragraphs 29 to 31. Now, basically, this is a judgment for the proposition, my lord, what is motive, what is foundation, because which is also a relevant consideration. That's why I consider it. I'll place, my lord, paragraph 31 and 32. At page 79. Consideration of the legal submission. Having gone through the salient judgment on the issue in hand, one thing which emerges very clearly is that if it is a case of deciding the suitability of a provisioner, and for that limited purpose, any inquiry is conducted, the same cannot be faulted as such. However, if during the course of such an inquiry, any allegations are made against the person concerned, which results into a stigma, he ought to be afforded the minimum protection which is contemplated under 311(2) of the Constitution, even though he may be a provisioner. The protection is very limited to inform the person concerned about the charge against him and to give him a reasonable opportunity of being heard. I think very lucidly, my lord, this passage has been made out, my lord. In my humble submission, this is the meat of the matter, my lord. What I am arguing for the last 1.5 hours, my lord, eventually it boils down to this paragraph. I'm reading it once again. However, if during the course of such an inquiry and allegations are made against the person concerned, it need not be pre or post recruitment, any allegation which results into a stigma, he ought to be afforded the minimum protection which is contemplated under Article 11(2) of the Constitution, and even though he may be a provisional. The protection is very limited to inform the person concerned about the charges against him and to give him a reasonable opportunity of being heard. Having noted the facts as they have emerged on record, can the preliminary inquiry conducted against the respondent in the present case be said to be an innocent one only to assess her suitability? Is it not apparent that certain aspersions were cast on the character of the respondent during the course of the conduct of this inquiry on her suitability? If that was so, was it not expected from a high judicial institution like High Court to afford her minimum opportunity to defend herself? So in Samser Singh, this court has observed that the subordinate judges are under the care and custody of the High Court. This custody and care certainly requires High Court to afford subordinate judges the minimum opportunity which is otherwise available to every other civil servants under Article 11(2). So, my lord, end of the day, any allegation you are taking note of, if it is stigmatic, then, my lord, hearing is sine qua non. Then, my lord, my last judgment today is, my lord, 2005 SCC 152. This is on the, my lord, motive and foundation. Para 28 at page 167. The important principles which are deducible on the concept of motive and foundation concerning a provisioner are that a provisioner has no right to hold the post and his services can be terminated at any time during or at the end of the period of provision on account of general unsuitability for the post in question. If for determination of suitability of the provisioner for the post in question or for his further retention in service or for confirmation an inquiry is held, and it is on the basis of that inquiry that a decision is taken to terminate his service, order will not be punitive in nature. But if there are allegations of misconduct and an inquiry is held to find out the truth of that misconduct, and then an order terminating the service is passed on the basis of that inquiry, the order will be punitive in nature, as the inquiry was held not for assessing the general suitability of the employee for the post in question, but to find out the truth of the allegations of misconduct against that employee. In this situation, the order would be founded on the misconduct and it will not be a mere matter of motive. Now, my lord, why this Dibrugarh police case was going on? To find out whether we are guilty of adopting unfair means while entering into service. And that is the factum. It was not for the purpose of finding out whether we are suitable for retention in service or there is a requirement of further extension of our service. It was a process towards gathering materials whether we are guilty in that case. And these facts have been taken note of, and the learned single judge in para 47, my lord, takes note of only the police report. And because there are no other materials. So this being the position, my lord, with utmost respect, I'll submit the learned single judge has erred in law, in my lord, dismissing the writ petition by making a distinction between pre-recruitment and post-recruitment. My lord, at least, my lord, my limited understanding, I have not come across any judgment of the Supreme Court where this distinction has been made regarding pre-recruitment and post-recruitment. I can understand, my lord, one is a provisioner and he will continue till he is confirmed. So, my lord, this concept is absolutely wrong and learned single judge himself has taken note of it. So, regarding ACS officers, my lord, therefore, my humble submission is a clear case where inadmissible materials were taken note of to arrive at the requisite satisfaction under Rule 20C, and therefore the whole thing vitiates. A serious prejudice has been caused to these appellants, my lord, on account of the procedure adopted by the state in purporting to discharge our services. State ought not to have done this. State could not have done this. Yes, had there been some materials on the administrative side, some preliminary in court by police arm organization, because preliminary in court is nothing but an administrative inquiry. So therefore, my lord, the relevance of the Supreme Court judgment in the Indraprit Kahlon and Joginder Pal assumes significance. Now, my lord, I am also dealing into a few APS matters, my lord. I'll just indicate the facts. Here, my lord, the rule is Rule 20C of the Assam Civil Service Rules 1998. In case of APS officers, my lord, the rule is Assam Police Service Rule 1966 and rule is Rule 16B. That's the only difference. But we have seen
Last time we had made a submission, we took a note of that.
Yes.
Provisions, we had
Yes.
recorded it.
Yes.
Civil service is 20C.
20C.
Police service is 16B.
16B of the
Taxation is 19.2.
66 rule. Yes.
Transport is 19.2.
Yes.
Labor
Yes.
is
Well,
16C.
I'm not arguing any transport matter. I'm arguing only. That's it. 16D is reads like this, my lord. A probationer shall be liable to be discharged from service, or in case of a person appointed to service under clause B of Rule 5.1, be reverted to the post of Inspector of Police if he is considered otherwise unsuitable for reasons to be recorded for continuing in service by the government. And for parametrium, slight change in the language, otherwise the purport of the rule is same. But there are slight distinguishing facts in the case of police service, my lord. I think so. Well, otherwise my legal submissions are same. A slight difference in the facts, which I'll highlight, my lord. I'll rely on this case, my lord. Item 64. 64 to the item number 64, my lord. নবখণ্ড পার্টিটো কোড বলে 208 নিবি itu নিবি yes কি পয়সা খাই ধরা পড়ছিল না
He's the only effort. Surely also not effort. 10 lakh টাকা loan.
My lord, I was referring to the main accused in that Dibrugarh PS FIR, my lord. His name is Nobokanto Patir. Now, in this paper book, item number 64, please come to page 208. Kindly see the, my lord, actions of the state. Page 208. Better Lordship, Nandi has got it. Oh.
Record of writ appeal 22.
A record of writ appeal 126, my lord. Horkhojyoti Bora.
No, this is not that.
I think 64 or no?
This 64. Item 64. No, 64 এ হর্ষজ্যোতি বরা। এটু হর্ষজ্যোতি বরা।
Particular investigation of times. The track is a big money, sir. We have been discharged. Yeah, he in service. Then that we can not. I read cut 27. How come the decision and same code? Oh, same code. Same code. Not even transferred.
What is that? That was complete for the other getting there. It's not that. Reply to me. Reply to me. Some complete.
To inspire public confidence and faith. So this is how.
Yes. Please come to page 208, my lord. Because my lord, this gentleman Nabokanto Patir, he was caught red-handed accepting 10 lakh rupees from a candidate called Angsumita Gogoi. And my lord, none others are not even named in the affair. It was during investigation of this case, my lord, that my lord, this gentleman was arrested. He was in jail for some time. Now kindly see, my lord. In continuation of departmental proceeding, which was drawn up by so-cause notice dated so-and-so, placing Nabokanto Patir, Assistant Engineer, Town Planning, Dibrugarh under suspension by office order notification dated so-and-so, is hereby reinstated in service and posted in Town and Country Planning District Office, Dibrugarh in the same capacity with immediate effect. Kindly see, this has the approval of the Honorable Minister of Town and Country Planning.
You know, Ajay Chaudhary, 2016.
Not for Ajay Chaudhary.
2016, no, not that. But principle is same, 2016 and 2019.
Not transferred.
There's something to be pointed out. He's a permanent employee. He wasn't one of the candidates who sat.
No,
for
that's
the-
okay.
Whatever it is, end of the day, he was the man responsible.
This is Mr. Corey, an art of what you call causing implicit what you call it's called prejudicing.
And Lordship, to take it one step further with Lordship's indulgence and permission. That's why I said seeking it with your permission and indulgence. This is also his entry into the services bona fide. So it only reiterates that a bona fide entry into the service and a misconduct during service will lead to the rules being
No,
applied.
that will hear you.
Of course.
That-
I said just on a factual thing, Lordship, may just make a note of para 43 in the judgment. My learned friend had said that the holy material was a police record. Just for records, 43 records that all the files of each and every person was brought to the court and perused by the learned single judge. That is recorded in para 43. And the second is because my learned single judge has relied on the first affidavit of the state. There was a second affidavit also which was filed. In Rumi Saikia's case, which was what my learned friend argued from.
I think my learned friend can point out when he argues the case.
No, I'm just only just saying because in case there is a gap, then also could have that advantage. That is annexure 12 at page 170 of Rumi Saikia. ACS.
Yes.
So these are only factual. I'm not.
Yes, yes. So, my lord, what had happened in this police case, they were appointed on 21/8/15, page 35, my lord. Now, if your lordship would kindly come to page 43. Yes. Now, my lord, at page 43, it starts. dated Dispur 15th of September 2017. Now please come to page 47, Milord. 1, 2, 3, 4. Serial number 4 from the top is Horkhojyoti Bora, that is the appellant number 1. Horkhojyoti Bora.
Yes.
Now kindly see, Milord, in the interest of public service, Horkhojyoti Bora APS, DSP, so-and-so is transferred and posted as Deputy Superintendent of Police, Border Headquarters, Simantapur, against existing vacancy with effect from the date of taking over. Now, my lord, a substantive posting is given. Why I am saying so, my lord? Please come to the bottom. It was issued by the then Principal Secretary, Government of Assam Home and Posting, Home and Political. The above posting of APS junior grade 2015 batch have completed probationary period of 2 years and are exempted from mandatory posting in the battalion for a period of 4 months as per OM dated so-and-so, as their services are urgently required in the field and in specialized agencies due to shortage of officers. So, my lord, virtually, this is a deemed confirmation order. Therefore, whether I was the probably as we have to put. Movement order, I got 39 meters. Nine.
That's good.
What probably you have seen that? So, my lord, what I would like to submit for lordship's kind consideration is, my lord, we were appointed on 21/8/2015 to the APS junior grade at page 35. Thereafter, on completion of 2 years, we are given regular posting. Now, kindly mark these words, my lord, in the serial number 4 on the top. Sorry, page 47. In the interest of public service, Horkhojyoti Bora APS, now they doesn't say I am a probationer. In earlier communications, they used to refer as probationer. He is transferred and posted as Deputy Superintendent Border against existing vacancy. I am not being posted as a probationer. And the concluding 4 lines of this notification also makes it clear that they have completed probationary period. But some meaning has to be given, my lord. What is the meaning? Otherwise, why this expression is used? They have completed probationary period. So, in my humble submission, my lord, it's a case where the APS officers of 2015 batch, where they have completed their probation, following completion, my lord, successful completion, they were given the postings.
We'll have to rise for the day because
yes,
I assume sister has a single bench.
Okay. And my lord, this was the only distinguishing feature. Otherwise, my lord, my same argument I'll adopt for APS officers. Only difference being, in the case of the APS officers, it is our case, my lord, that they have completed their probation period. Therefore, my lord, there is no question of invoking Rule 16D. In their case, a regular departmental inquiry was otherwise imperative. Reply the Harim
Mr. Chaudhary and Mr. Kohli and others who are here in the matter, we are proposing that we fix 3 consecutive dates from Monday, Tuesday, and Wednesday. The matter. so that continuity can be there.
I have proposed lordship a lot to wait. I will argue finally, so I'll appear on VC, that's not a problem. Only Monday I have some difficulty because Monday I have
What is the
before final hearing matters. I may find it difficult on VC.
One second.
Monday's
My
gap
lord,
is given that.
Wednesday is a holiday
Oh, yes, Wednesday is a holiday.
because of election, Panchayat election.
Okay.
I am on the matter, in this, I have a matter in this case about 7, 8 candidates. So let me start on Monday. They can note down, there is no, because another 7 will be a holiday. I can start my particular.
Good.
They can note down.
Anyway,
Good.
I'll appear in the.
So at least 7 and 8 lordships can continue.
Because your lordship is hearing this matter. Again, if there is a gap, again there will be a problem.
Yes, that's the biggest problem.
Only thing is perhaps, my lord, because other matters will be there, we'll have to start at 2 o'clock.
Yes, will it be at 2 o'clock?
2 o'clock is okay.
Yes.
Just remind me in the
My lord,
stuff.
4 o'clock won't be a problem because the matter is fixed at 11 in Delhi, so that should be discussed.
For the whole week,
Uh,
my lord, I have no problem on any date, my lord, excepting on date, my lord, when I will be out of station, my lordship will have to accommodate me subject to death, man.
So lordship was fixing Monday, Tuesday? He can take a call there. Or will the lordship be continuing later in the week also 8 and 9?
We are not fixing it right now
He'll be there.
because
When the Monday matter will be there, my friend will answer.
all sides are represented. The submissions of Mr. Ken Chaudhary, Leonard Senior Counsel,
He tried to reject also, right?
duly instructed by his, duly assisted by his instructing counsel, is concluded in WA. Your first matter was WA 101 of 2020
And 126.
and WA 126 for 2020. Comma reserving right to reply. Next paragraph. We let this matter be listed on, let me 5/5/2025 and 6/5/2025 for further hearing. Just remind me, remind us, we'll take it up at 2
For
o'clock.
taking out 2 o'clock.
I will oppose the pressing.
Yes.
For a VC link.
Yes, you will definitely get it. You have to, I think, just mail it and they will connect you. The difficulty is only that when this is on, we are off.